order the meeting of the Court Reporters Board. This is Friday, September 23rd, 2016. We're here at the San Diego State Building and the Eshelman Auditorium. Ms. Brennan, could you do roll call?
Yes, Davina Hurt,
Present.
Ms. Crom,
Here.
Ms. Lisinski,
Here.
Ms. Nocella,
Here.
Ms. O'Neill,
Here.
Harvey.
Thank you. We'd like to remind everyone that proceedings of the board meeting are being recorded and webcasted. It's requested that anyone wishing to speak on board as they're recognized. It's welcome but not required that the speakers identify themselves. And also, since we're being webcasted, if everybody can speak really loud and clear for our videographer here. Well, let's move on to agenda item 1. This is the introduction of our new board member, Carrie Machilla. Welcome. I'd like to give a brief summary of our board member here. She's a director of government relations at the Disneyland Resort. Carrie is responsible for the resort's overall government relations and policy initiatives and efforts, developing strategies and plans to help ensure a favorable environment for resort operations and expansion. She was also an attorney in Sacramento. She obtained her JD at the University of Pacific, McGeorge School of Law. She served as an adjunct law professor at Chapman University. And before then, Carrie worked at the city of Anaheim in the public utility department as an attorney. Going a little bit further back, she was also has a Bachelor of Arts in Legal Studies and a minor in Spanish from Chapman University. And her political career, one would say, she served as an intern for the United States Supreme Court and also Congresswoman Loretta Sanchez. Thank you for being here.
Absolutely. Thank you for the warm welcome.
Yeah, it's a pleasure to have you here. We definitely need another analytical mind on the board. There's some myriad of issues that we are working through right now, so thank you for being here. Any comments you'd like to?
No, I look forward to getting involved and learning a lot, so I'll ask a lot of questions.
Good.
And lean on a lot of the experts and a lot of the board members. So thank you. It's a pleasure and honor to be here.
Thank you. All right, so with the addition of Ms. Machilla, we have a resolution for John Rue, who was a board member that's moved on to other opportunities, which brings us to agenda item 2. We'd like to present a resolution that states John K. Liu has faithfully and devotedly served as a board member of the Court Reporters Board from October 25th, 2013 through June 13th, 2016. He was integral in developing the board's strategic plan 2015-2018 and provided direction on reaching its goals and contributed to the scope of practice to regulatory revisions. He strongly advocated for protection of consumers from corporations practicing outside the requirements of the law set forth by the state of California. Throughout his years of service, at all times, he gave fully of himself and his ideas and acted forthrightly and consistently, always with the public interest and welfare in mind. He has more than 18 years of professional experience as an attorney at law in complex corporate and securities matters, and so therefore it's resolved that the members of the Court Reporters Board expresses a heartfelt appreciation to John K. Liu for the outstanding contribution he has made over the time. So acknowledging his service, and at the last meeting we said a lot of great words, but would anybody like to add anything just in case he's watching?
We don't have microphones, do we?
Oh, they're on the side.
You're super good. We're just recording on these microphones, but we've got good.
Okay. So I'll just quickly say he will be missed. He was a wonderful addition to our board, and we wish him and his family opportunities ahead of him.
I would like to see you also wear cool socks.
He did.
He has a great sense of humor.
Right now. And I would like to say too that what I really appreciated about John is that even though his tenure on the board was, short, his input and analysis really was significant in shaping the decisions and decisions of the board, and I really appreciated that input in our discussions. So I just like in the resolution, I thank him for the opportunity to work with him. I really enjoyed it and wish him the best in his endeavors to come.
Well said. Are there any public comments?
Could I add a staff?
Absolutely.
I just want to acknowledge the fact that one of the favorite things that I found with working with Mr. Liu was how sincere he was in really wanting to protect the consumer. And he was always having that uppermost in his mind, and it mattered a lot to him that he made a difference and worked hard to that end. And so when we're saying that he gave selflessly, he really did. So it was greatly a real opportunity for me to be able to work with him.
He will be missed, for sure.
Absolutely.
Would someone like to make a motion to adopt the resolution that's on?
I so moved.
Okay.
Second.
Any additional discussion? All right. Roll call on the vote.
Public comment, Madam Chair, public comment.
Sorry, I said public comment earlier, but this is the time to also do it. Thank you. Public comment? Nope. All right. Roll call.
Ms. Crum,
Yes.
Ms. Lisinski,
Yes.
Ms. Nocella,
Yes.
Ms. O'Neill,
Yes.
Ms. Hurd.
Yes.
Motion carries.
Okay. The motion carries. We'll miss John. All right. So now, agenda item 3, approval of May 26, 2016 meeting minutes. Everybody has a copy of the minutes that are distributed after reviewing. Does anyone have any additions or corrections?
No, that's amazingly underlined.
I'm looking at you too. All right.
I did not, I'm not saying that right, I didn't find it.
But she looks.
Wow. That's unheard of, huh? Okay. No one else? Okay. So the minutes will stand as distributed. Can someone make a motion to adopt the minutes?
I make so motion. I second.
Public comments? No? Okay. Let's call for vote.
Ms. Crum,
Yes.
Ms. Lisinski,
Yes.
Ms. Nocella,
Abstain.
Ms. Hurd.
Yes.
Excuse me, I'm sorry, Ms. O'Neill.
Yes.
And Ms. Hurd has heard you say yes as
Yes,
well.
yes, yes.
I apologize. Motion carries.
Thank you. Okay. And so now we'll move to agenda item 4, which is our legislation that's relevant to court reporting. The first part of the legislative agenda item is an update on the sunset review and license fee cap increase, AB 2192. Would you like to talk, Executive Officer, about what's going on in the
Sure.
legislation?
I'm very happy to report that this bill, the 2192, is in the governor's office. So we are expecting and hoping that he will sign it. Since he has not signed it yet, it would be appropriate for us to get a letter in urging him to do so. It only gives us 3 years, but it does include the fee cap increase language, which is really important to us to be able to continue the transcript reimbursement fund.
Right. I definitely think that the fact that it's before the board is a good, before the governor is a good thing. We should send a letter just because it's still sitting there and he has to the 30th to do something. And so a little nudge and pull with all the things on his desk would be good. It's very hard for us to get that fee cap increase because of the tax label. So it's a win-win if it passes for all of us.
When it passes.
When it passes, that's right. Are there any comments from board members? No?
I support the letter.
Yes.
Oh, do you want to know if I support the letter? Oh. Do we
Yes.
need a motion?
We do.
I move that we write a letter in support of this bill to the governor.
Okay.
Second.
Okay. Any public comment? Okay. No public comment? Should we do a roll call?
Was yours?
Hands? Yeah, the second was five.
And just for clarification, may I ask a question for
Yeah, sure.
clarification? So knowing that the deadline is September 30th, and knowing that today is September 23rd, when will the letter be written and submitted?
Monday.
ASAP. Okay, any other questions? No? No further discussion? Let's take a vote on the motion for the letter.
Ms. Crum,
Yes.
Ms. Lisinski.
Yes.
Ms. Nochella.
Yes.
Ms. O'Neill.
Yes.
Ms. Hurd.
Yes.
Motion carries.
Thank you. I also like to thank Assemblymember Salas, who introduced the bill, as well as Senator Hill, who was the principal co-author from my county, as a matter of fact. Thanks to them.
I'm sorry, it would be appropriate to send them a thank you letter?
That will be my next question.
Oh, you are just so.
You're ahead of it. I know. So can someone make a motion to, yes,
May I just add, there were a couple of key staff members from both the Assembly Business and Professions Committee and the Senate Business Professions and Economic Development Committee that worked tirelessly to make sure that this all came together. It was quite the challenge because of the tax implications of it. So we'd like to include those in the list of thank yous if that meets with the pleasure of the board.
no, I think that's a great friendly amendment to add the legislative consultants. Gabby comes to mind, and I think there are a couple other.
Mark Mendoza on the Senate side, but the two of them are good.
Sarah.
And Sarah, that was the other name, thank you, Sarah Mason. Okay, so would someone like to make a motion with all that was just said?
Sure. I move that, on behalf of the board, a letter is submitted to the co-author of this bill and also to the legislative consultants who also worked on it.
Okay, is there a second? Thank you.
I didn't hear the second.
Rosalie.
Thank you very much.
Okay, is there a public comment? No, all right, and then any additional discussion or questions? All right, let's call to vote.
Ms. Crum.
Yes.
Ms. Lisinski.
Yes.
Ms. Nochella.
Yes.
Ms. O'Neill.
Yes.
Ms. Hurd.
Yes.
Motion carries.
Thank you. Moving on to sub-agenda item B, the status and update, a discussion of the various legislative measures that's before.
This here is just the list of bills that we have been tracking during the legislative session. And because it's the end of the bill cycle, it's just what happened to them. So it's self-explanatory. If there are questions, I would try and answer them, but
Okay.
it is what it is.
I have one question on the AB 1033. How do you think this will impact for reporters, freelancers, business owners, these small?
Which one did you say, sorry?
1033? AB 1033.
Got it.
Oh,
Yes.
It's really a technicality, I guess, for the red. When we're dealing with red packages and things like that, it's not going to have a day-to-day impact on what we do.
Okay. My other question with AB 2629, when was the last time there was an increase? Do you know?
25 years ago? 1991?
Yes.
Oh, I do have an update on the retired one, or is it?
Yeah, that's 2859, where it allows all programs within DCA to establish by regulation a system to issue retired licenses with specific limitations.
Yes, that was from the governor, so that's going to be enacted. And it's only peripheral to us because we already have this language in our statutes.
Okay. I think the retired license option is really important for this board. I'd like to see us delve into that, especially with the North Carolina decision and the fact that our executive officer is a licensee and how she can retain all that work she's done over the years but still help the board moving forward. Are there any comments from board members on this bill?
Yeah, I would like to see, maybe for the next meeting, an agenda item on this, because I also see implications of, I'll say, for example, we do get a much needed increase in the annual license fee. I can see many a retired court reporter from court deciding that they're not going to renew their license. And I can see value to having a retired license category in the sense of, number one, it would still then provide some income to the board. Number two, they, official reporters will still get orders for transcripts even though they're retired. As I told other people, you could be on an out island in the Tahiti area and they will find you when they find transcripts, 6 years after you're retired. So, but they cannot sign it if, if they don't have a license.
Yeah.
And so, and we have ways of handling that, but it would be much cleaner if the reporter could prevent a transcript if the reporter wants to do it. So I really think it's something to explore.
Well, it's on the governor's desk, so.
It's on,
And
it's on.
It's
Well, I
on,
mean,
so.
yeah,
But I mean, you're wanting to know how we can.
yeah, how do
Yeah.
we, yeah, what do we, as far as, we already have that language that allows us, that gives us a retired category. I would really like to explore fleshing that out and really defining what comes under that retired umbrella.
And how it can be implemented,
Yes.
how the impact it is in the industry,
And
as
I
well
would,
as consumers.
and I would suggest also not only the official world, but for the freelance world, is there's an aging population of court reporters, and so I think it would also be beneficial for deposition reporters and freelance reporters to flesh out all the ramifications of the retirement status category.
I would put that on my note for a future agenda for our next meeting, and I would just let the board know that that would be accomplished through the regulatory process.
Okay.
So that's where we next.
Okay, great.
Okay, I think we'll take up with SB 270 in a future agenda item. We don't need to delve into that right now.
270?
Yeah.
Yeah, and then, right.
Yeah, we're about to delve in. So, any other questions on the legislative side? Okay. Let me make sure I asked my questions here. Perfect. All right, let's move on to agenda item 5. This is a discussion and possible action regarding statutory and/or regulatory violations by non-CSR-owned firms. I think a background for this is really important. We do have a new board member. There are a lot of folks who are probably wondering how this agenda item has been placed and how it's evolved. It's important to know, just from my quick research, that this issue has been plaguing the board since 2007. It's not an easy issue, as everyone knows. In fact, it's quite complex. It's not clear. And I think anyone selling that it is an easy fix is being a little disingenuous, since it's still coming around since 2007. And there's been, and there continues to be many lawsuits on this topic. What I think the latest is Washington.
There were some active in Washington and also in Louisiana.
Oh, and Louisiana, Florida. So this is a long-standing issue that a lot of states are dealing with, and they're trying to find answers to. And this board is definitely committed to doing that, in fact, since 2007. In short order, in 2007, there was a task force created on firm registration. In the end, they recommended to amend AB 46, and they were not convinced that firm registration was the answer, nor were they convinced that the legislation or the legislators would go for that. So it went away, and they recommended the board to continue to gather complaints. I think, Ms. O'Neill, you were here. If you want to add something, if I'm missing something, let me know. But they were working hard on this issue.
I was actually on that task force as a board member at that time.
Yeah, so if I leave something out, let me know. In 2008, the board worked on changing the language. The government, legislators, everyone worked for at least a year. Whenever you try to change a regulation, it doesn't happen overnight. So that took its long journey. In 2009, I believe, Bill 1461, the iron rusting bill, that was sponsored by DRA and CCRA, popped up. Unfortunately, it failed. We move on then to 2010, the lawsuit that the board was involved in. We were not successful at ending the unauthorized practice in that lawsuit. It went on for several years. We spent a lot of money. And as everyone knows, this board is very lean. We have 4 staff members and a small budget, so that went away very quickly. And so that brings us to 2013, 2014, where we've had, as everyone knows, a lot of closed sessions about strategizing on how to best use our monies that are very limited, but also being very effective on making sure that those folks who are doing unauthorized practice is held liable and is enforceable. And then, here we are, 2015. We have the 270 Mendoza bill that was sponsored by CCRA. They did what they could to try to push that through. I think they brought a lot of light to the issue. We were kind of brought the board after the fact, more about a blessing of what they had brought together. And of course, we worked with them as best as we could. We never could send a letter if everybody could remember to support 270 because we didn't exactly have the language, but we passed on that we liked the spirit of what was happening. And unfortunately, it too did not pass. It failed. And here we are, 2016, September, needing to further discuss this and figure out a path. So we've done a lot of discussions in closed session behind doors. And now it's the time to bring it to light. I think the time is right. CCRA paved a road, and I think there are folks listening right now. So any comments? Who would like to start?
I don't know, I've been on the board, I've been on the board since, I don't know, 2009 or something like that, and this topic has come up since I've been on the board. Routinely, regularly, it never goes away.
Yeah. Maybe let's hear a little bit from
No,
the
let's
public first to start with, to see if there are comments, and then we'll dig in if that's good with the board.
Good morning.
Good morning.
Ms. Rosinski, Ms. Neal, when I started working on it, I had a full head of hair for a long time.
I can attest to that.
For Ed Howard. The first is her the recitation of the timeline is very solid, but mildly incomplete in that in many ways the problem of this predates 2007. What happened in 2007, which is really illustrative about what happens when the board convenes a task force, is that the board simply didn't have the Muscogee-Knox Act on its radar. And in the process of preparing our testimony for that, through the war story, I was on a conference call with Stephanie Grossman and Tony O'Neill, and we were lamenting the fact that there appeared to be, at least in the board's view, no power or regulation of professional corporations. And I said, well, have we actually looked at the law? And it was there that we stumbled upon the Muscogee-Knox Act, one of the more important, but one of the more obscure areas of law. Not a single report in Sweden.
Could you define that for those who are out there wondering what the Muscogee Act?
So the Muscogee-Knox Professional Corporations Act, which was passed in 1968, was the act that made corporations be allowed to provide professional services. Prior to that, professional services could not be, licensed services could not be provided for in a corporate form. And the reason for that is actually very prescient today. The reason is because corporations are in part invented to shield individuals from liability. That's the reason we created them. Whereas licenses is a public policy technique designed to enhance personal accountability for your behavior. So if a corporation writ large misbehaves, for example, just a plain vanilla corporation, if it doesn't have a license to take it away, what can you really do to it? Well, you can sue it for civil damages. Or you can get an injunction saying, stop that and don't do it again. But you don't have the additional threat of being able, except in very few instances, to take away that business's ability to be able to operate at all. Contrast that with those of us oldest here, where most of us are licensees. I have a very personal skin in the game as to you do Ms. Herman, as to you guys
I'm sorry, Mr. Howard, you tend to
I'm
drop
sorry.
off, and so it's gonna make it hard for us.
So we have a very personal stake in the game. If we misbehave, our regulatory agencies can take away our right to do our profession. It's a very powerful incentive to obey the law at any given time that plain vanilla corporations simply don't have. So prior to 1968, through case law, it was simply illegal for anybody to provide professional services through a corporate form. You could only do it through a license or through some sort of entity that was purely licensed. 1968, Muskogee-Knox was passed to allow people to take advantage of providing professional services through a corporate form. But the authors wanted to maintain, the legislature wanted to maintain the level playing field between corporations and between licensees and firms. And more importantly, they wanted to maintain the personal stake that you get from a license, all of it to protect consumers. Because if you don't, what distinguishes licensed professionals from everybody else is that the legislature has decided these professions are so important and so capable, if not wrong, that we have to make it hard for people to get into them in order to prevent future consumer harm. So what they did is they passed the Muskogee-Knox Act, and there are certain provisions in there that require the kind of personal accountability that you see with individual licensees. And so that, not very short-winded explanation of the Muskogee-Knox Act. But what happened was that from 2007 on, the Muskogee-Knox Act and the way that other boards treated corporate practice started getting into the circulatory system of this board. So it significantly predates 2007. It was something that happened in the custom and practice of this board before we were all here. That didn't happen in other boards. Medical corporations, no such thing as big non-doctor-owned corporations in California. This is unique to this profession.
I think I should be clear too, when I speak of 2007, that's when it got really busy, and
Yeah.
that's when a lot of eyes and the spotlight was on. I think I understand that that's what was happening before.
Yeah.
But to me, the bigger part is what's happening closer to today, and how we've tried so many different things along the time. Not because it's an easy, but it is a complex issue. And as my daughter would say, we've been given a hand many times. So are there any comments on today an unauthorized practice that you'd like to contribute?
Just a few. And thank you for your indulgence. First, I think it's important, we also want to thank CCRA for there was a period of time where we were in support of it. There was a period of time where regrettably we had to withdraw our support. But at the end, the bill, although it was an unorthodox approach at the end, it was something that we supported, and we do want to thank CCRA for bringing it as you have Madam Chair. I think,
Mr. Howard,
Sure.
you need to adjust the mic.
No, I can't hear most of what you're saying.
I'm sorry.
Can you just bring it up?
Not doing his job.
Marco.
Is it working? Can you hear right now?
Yeah.
Yeah.
Is that better?
Oh, well, much better.
There are several thoughts I have. The first is when you see issues of this importance to the profession, commonly it is the regulatory boards that take the lead. That is in part why, when it comes to this issue, DRA and at various points in the past, as well as CCRA and the other trade associations, have worked through this board, first from 2007, including AB 1461, through most recently with the filing of our complaint against 10 different out-of-state companies. It really is important from the eyes of the legislature and the governor to see that it is the regulatory board that's taking the lead on addressing the issue. And that actually brings us to a nice symmetry to the task force that was convened by this board that began the entire process that leads us to here. The second is that the legislature, before a regulatory board goes to the legislature and asks for legislative changes of this magnitude, commonly staff and members want to know whether or not you have used the inherent powers that you already have to promulgate regulations to address the gaps that may exist in the current statute. So I'll give you one example, if I may, Madam Chair. One of the things that we heard for the first time at the board sunset review hearing was that the prospect of having to litigate repeatedly what was and was not a professional corporation under Musconian laws, the definition pivots off of the word rent, off of the word rent, that was potentially daunting and impeding. Well, the definition of what is and is not a professional corporation is something that can be defined and refined by regulation using this board's inherent powers. There may be other areas, both between the Business and Professions Code, between the examples in other licensed professions that have not had the problems that we've had in unlicensed practice, and between the Musconian Act.
What states are you aware of that have not had similar problems?
Well, they have more robust laws and regulations than we do. So I can give you examples if you like.
Sure, this is the time, yeah.
Sure. So there are two states that, or three states that I'm aware of that have laws and/or regulations that are more robust than California's, and they're of interest to us and I think to CCRA because they're the home states of two of the major opponents to CETA. The first is the state of Texas, not a state known for being against business unfriendly. It is also the home state of U.S. legal. That state has laws that actually brought this. So, that state has a definition of professional corporation that expressly includes independent contractor relationships.
And they also have firm registration.
They also have firm registration. Georgia, for example, has, I believe Texas also, and forgive me, I might find the word back later, I just forgot. Texas also, I believe, has some form of licensee being on the hook. But my memory's a little fuzzy on that. Georgia likewise has a definition, which is the home state of Esquire. Likewise has a definition of professional corporation, or the analogous term, that embraces independent contracting relationships. And also, and more interestingly, has a provision in its law pivoting off of members, the concept of personal accountability. Georgia also has a statute that allows the board to impose fines and seek court orders against individual officers and directors of reporting corporations, regardless of whether they're licensed. So the question of what exists in other states, what other states have done by dint of statute or by regulation, and then, as in many, many other instances that I've been involved in for my consumer group, the ability of the executive officer, your executive officer, to have private conversations with executive officers about other states, to learn about what really does work beyond just the superficiality of the statute or regulation, what really works, how is it functioning, how is it. That's absolutely indispensable. I sit on a task force for the Board of Accountancy called the Mobility Stakeholder Group. And one of the major benefits of that is that it allows the executive officer of that board, as Patty Bowers, to talk privately and candidly with other state EOs about what works and what doesn't, and that influence comes to regulate out-of-state CPAs. So I think that one of the things that the board had asked for in its deliberations about 270 was, in fact, research about what other states are doing, not just their laws, but what actually is working. And I think that would also be useful in terms of talking to other boards here within the state of California. The medical board, for example, has analogous laws to this one, certainly far greater resources. but has analogous laws to this one. It has a prohibition on obviously medical corporations from being here.
You know, their enforcement division is the size of our entire staff.
Oh, exactly. They also have an individual, there's a webcast that I watched in preparation that talks about the corporate practice doctrine before that board. In that, to underscore it, they have a designated enforcement person who just handles questions related to corporate practice. But there are many smaller boards, not as gigantic as the Civil Liberties Board. The Board of Architects has analogous statutes banning corporate practice, requiring individual accountability of licensees, conversations both out of state and between state agencies about what works and what doesn't. I think it's quite important. And then I would note two other things. So if I could a little more over them out. But the first is that the legislature wants to know that you've exhausted your ability to deal with this question by regulation, using the power they work with. When I was chief consultant at Sunset Blue Committee, it was one of the very first things I asked. Before you come to this building asking for statutory changes, have you actually taken a look at what you can do by regulation? And the support for that comes, by the way, Madam Chair, from BMP subsection 8007B as in dog, which sets forth very broad statutory powers.
I'm sorry, can you repeat that?
Sure. It's 8007D, and it sets out very broad powers for the board to, quote, adopt, amend, repeal rules and regulations as necessary to carry out the provisions of this chapter.
So in your roundabout way, you're saying the board are not using the powers that are inherent to them?
And I think that the board has yet to, I wouldn't say that, you've yet to explore all of the things that I think can be done through regulatory powers. There are two things that you have, which I think may have been left out at the time.
Well, I think also, don't forget that you won't be privy to our closed
Of course.
sessions, which is several years in the making. There's several discussions of that.
So there were two things that
We're there now, and that's why we're having
and
this
that's,
agenda item.
you couldn't be happier about this conversation. The two things that you have done to try and further it by regulation is that after the U.S. legal decision, where you lost on the site of fine question and prevailed as against the major defense of these firms, which was we're just middlemen, we're just independent contractors, we don't fall under the definition of what's going on. You won on that. Never forget that was the reason you went into court, was to prove that. Right after that, you amended your regulation, your standards of practice regulation, so that it didn't just apply to licensees anymore, it also applies now on its face to professional corporations. The reason you did that was in part in an effort to try and facilitate enforcement. And then your former excellent counsel had this great idea of promulgating regulations related to the standard of practice. Again, one of the chief reasons in public to do that was to try and facilitate enforcement. Both of them were positive. But the board has yet, since that time, I think really studied what it can and should do by district regulation. That's a very powerful option available. It's a lot easier for this board to promulgate a regulation than for Ms. Ryan, Mr. Hernandez, and us to get statutes done. The final thing has to do with legislation. You may conclude that there are certain things that are required in order to make sure that corporations are held accountable for providing the same kind of services as firm licensees and by firms. And you may need legislative changes in order for that to happen. Again, going out and doing the research about what works in other states, what doesn't work in other states, what works in other boards is critical to being able to prove that up in the legislature, especially since I think it's a target-rich environment and being able to hoist our opponents by the laws of their own states in some instances. But the critical piece of that is that your board, the board, through conversations with other executive officers, will be able to find out what really works and what's happening on the ground in a way that at least we can. And then one other comment, and thank you for your patience. From the consumer's point of view, and one of the things that I admire about you, Ms. Hurd, but the rest of the people here is the rest of the board members, is really, of all the boards that I go to, the interest of consumers is not something that anybody has to remind y'all of. It comes up every single time, every board meeting. It is very, very much pivotal for the interests of consumers that there be a very personal stake for corporations to obey the law. That is the reason why this profession is licensed. It is licensed because there needs to be a personal stake in the game. There needs to be a personal stake in the game to incentivize corporate executives or corporations whose very existence is owed to limited and shielded liability. It is critical that there be individual stakes in the game. That could be by way of the Georgia law or something like it, where individual directors and shareholders, notwithstanding the fact that they're not licensees, are held liable. It could be the model used by pharmacists here in California or contractors, where you have a broader corporation, but you have a licensee who's in charge of the licensee functions, production and delivery, for example, in the context of a corporate reporting corporation, where there's a licensee manager in charge. And it's not theoretical. The board of pharmacy has to approve the pharmacist in charge. And then I think the last question has to do, of course, with enforcement. And this is where the conversations that are held in closed session will really inform what the best thing is to do in a way that we simply can't know about. And that is, the best laws on the books, we have very strong laws on the books right now, don't work unless you can enforce them easily. One of the things that happened between 2007 and 2011 was simply persuading first DCA counsel about this, but then the Attorney General about the importance and validity of bringing that case. The legacy of AB 1461, the late Andrew Ruskind's bill, is there was committee analysis in that, during that bill, that said that corporations were covered, and that was one of the critical pieces that persuaded the Attorney General to go forward. So, we can't know what we're talking about behind closed doors.
That's why we're talking today.
I understand. But the question of what kinds of laws, always mindful that there has to be individual skin in the game. Always mindful that if you don't have that, if you just do firm registration, you're done. Doesn't matter how easy it is to enforce if it doesn't provide a powerful incentive for people to obey the law. So, mindful of that, enforcement is critical. And then the ease of enforcement is critical with one asterisk, and I will be quiet. The smartest thing I've ever heard about government enforcement generally, but about DCA enforcement in particular, was by a man named Paul Richards. Paul used to be the number 2 at the Department of Consumer Affairs in charge of enforcement. And now works for the Assembly. And he said once in a meeting, our problem is that we win too much. And what he meant by that was that it is too common for the licensing agencies to keep looking for easy cases. These are corporations that do not want to obey the law. They do not unless they are being told to. So whatever you're going to do, whatever the board decides to do at the end of the day, they're going to be in for a fight. You can't avoid, they know right now that the board will not file cases. They know that they will do that. So whatever you write in the future, you're going to have to go to court in all likelihood to prove it up.
So I want to just maybe first start off by saying I really thank DRA and all the work that you've done on this topic. It's been very helpful, all the associations kind of giving and putting in to make this a good conversation. We've received several memos from you on what you think about this topic. And I have to say, you suggest throwing everything but the kitchen sink in on doing things. And for us, you've already pointed out that we're lean, we're not the medical board. And so could you speak to maybe prioritizing what those things are?
Absolutely.
What do you think because I heard a lot, I mean, other board members can chime in. You just spoke a lot about the long list of things, and we know that long list.
I was gonna ask top 5.
Thank you. What are the, I was gonna ask top 2.
Can I do it 2.1?
And you only have a sentence to say it.
Like a bullet point.
You can only say
Can I have a
it.
semicolon?
That's just,
Thank you.
That would be helpful.
yeah, that would be.
The most important piece is exploring what this board can do by regulation right now. There are a number of options that I know are available to the board immediately because I've spoken about it with other council before. And among those, this is the second one, among those regulations to look at is defining what is and is not a professional corporation using existing statutory authority between the Business and Professions Code, the Moscone-Knox Act, and the Code of Civil Procedure. All 3 of those statutory schemes use words that can be used, in our opinion, to serve as the lawful basis of a refinement regulation. But to your point, it's regulations first. And then I'll point out, so maybe an ellipses, that is, when it comes to the statutory requirements, I stumbled upon in preparation for this morning a statute at the very beginning of the Business Professions Code, which I had never digested before. But where I found it was in the task force testimony from 2007. And it is in B&P Code section 129D. And it's in the definition of what a board is. And a board is required every year by statute to evaluate complaints once a year and to make recommendations to the director and to the legislature about statutory changes that it deems necessary to implement the board's functions and responsibilities.
And you believe we haven't been doing that?
I'm not aware of proposing a statute yet. But I do think the first thing that you need to do is exercise your inherent regulatory powers and consider regulatory actions.
So on number 2?
Number 2 would be statute. Pivoting off of what you can't do by regulation. Making recommendations to the director to get buy-in there, and to the legislature about what statutory changes are needed based on number 3, your research. Your research about what works and what does not work in other states, and what the opponents of SB 270 are already doing.
Do any other board members have questions? No? Okay. Thank you.
Thank you. It has been long.
It's only
One
just
of-
begun.
I know. And one of the things that we've uniformly done is look to the board for leadership. This question needs to be resolved by the board in a way that hugs it as this is long after I have no hair at all, which I surely could be doing now. It's the board and your successors don't have to enforce the laws that you write.
Thank you. Are there any other? Sure.
Hi, how are you? I'm Brooke Ryan, president of the California Court Reporters Association, and I just want to make sure that we're all aware of what's going on, or where we're headed at least. CCRA has a committed author again to carry this bill next year. And what is really exciting, and I believe you're all very aware because of Ron was control in SB 270, is that Senator Mendoza, worked tirelessly on this bill. There is no doubt. Sorry. Senator Mendoza worked tirelessly on this bill. And at the end, we had the help and support of the Speaker of the House, the Pro Tem, the Chair of the Assembly Judiciary Stone. He was great. So I do think that there's great movement for this. There's surely a lot of talk about it. So not only do we have a committed author, we have hired a media consultant. Everybody's working in conjunction because I think that this is seen as a priority and a very serious problem. That is a very good thing. And I want to point out that SB 270, Mendoza bill, made it a lot further along than the Ruskin bill. So we're very excited about that. I hope you are as well. So, you know, for sure we're going that way. And I wasn't sure if we were talking about this memo that I got this morning about a task force, DRA asking for a task force.
Oh, you received this memo as well, dated September 19, 2016?
Yes.
Did you have an opportunity to read through it?
Yeah, as much as I could, yeah.
Yeah, do you want to fact check some things, or do you have any
I just,
responses?
yeah, I have some responses about it. Some things that are interesting is that I don't know that a task force needs to be appointed just for this bill or specific, just for this issue. I'm sure that information gathering or informative task force or something to help along the way would be great, but for specific language, I'm not sure about. I don't know that the CRB will carry this legislation. I'm not quite sure if that's what they're asking. You don't have my understanding is you're a lobbyist, and I'm not quite sure that the board's nimble enough in that situation because, as you know, we get calls in the middle of the night. And I'm also not sure if they're wanting the CRB to co-sponsor it with us, which would lead to a lot of questions and a lot of concerns. Not that we couldn't work with you, it's just that if the governor, you know, called in the middle of the night and it was amended, is the board or the task force then forced to go along with those amendments? I don't know quite how that would play out. Not that we couldn't figure it out for sure, but I just want you all to know we plan on carrying this bill again. We already have an author. The train's leaving the building pretty soon, but we look forward to working with you again. I mean, Yvonne was there at so many of our meetings and had information and was fantastic, of course. So anyway, we do plan on working together. And so, you know, and Senator Mendoza and CCRA let DRA and the CRB know of everything. And we took input and went back and had technical review on amendments and whatnot. I mean, everybody was involved, so.
So would CCRA be open to us putting forth language that we thought was appropriate?
You need suggestions? Absolutely. We take everyone's suggestions. Here's the issue I'm at. We have a brand new board coming in, right? And our first meeting is November 19th and 20th. And I can't tell you what they're going to vote on, what bills to carry forward. I can tell you this, every single new board member coming in has been on the legislative committee and or attended our CAT training, which is our advocacy training. So they have an idea. I'm pretty confident that they will, you know, vote this in, but I can't say that until they do vote on it, and that would be very unfair for me, so.
Can I ask a question?
Absolutely.
So why do you think this bill failed? And what would you do differently? Is that too broad of a question
No, it's not too broad of a question. I mean, why did it fail? There's insurance companies were involved at the end. They were brought in at the last minute. It was big and it was a fight for sure. But what are we going to do differently until we sit down with the author and everyone involved? Until we sit down with the author and everyone involved and strategize. I know that the author himself has some strategies in mind, but we haven't met with him yet. And when we're going to meet with him, I'm not quite sure, but I'll inform you guys, of course. I'll send an email right away, what, you know, and most likely Yvonne will be involved, Ms. Finner will be involved, so.
Any other questions from the board?
I just have a question. So I know when bills go through the legislature, it is always tough to read the tea leaves. And oftentimes it is a fight. And I know CCRA is really interested in moving forward and authoring the bill. I would say to the extent that CCRA would be willing to work with the board and be willing to work with DRA together. I'm all about if the most unity that you are able to present to the legislators is always the best. And that's the question that I'm sure you're going to get when you talk to the legislators is where's the board and where is DRA? And I know I'm new to the process, and so I'm sure I'll hear some of the war stories about 270, was why, DRA supported it, and why they pulled their opposition, and all of that. So I would just encourage, to the extent that we all can get together and be a united front as we move forward, I think that is the most beneficial for the profession as a whole.
Absolutely, and that's always our goal. And like I said, we constantly, CCRA, our lobbyists, as well as Senator Mendoza and his staff, always kept everyone informed of what was going on.
Yeah, I think to that point, there's a difference to being kept informed and being a part of the process.
Oh, no, any amendment that Mr. Howard gave, I mean, we thoroughly looked through it. I mean, and everything that was looked through. There's no doubt. And many were accepted and many were not, and that's how it goes. I mean, that's, and as you well know, the BNP committee then rewrote the darn thing, right? That's out of our control. I mean, that's just how it goes, constantly.
Do you have a question there? Just comment, that's good.
No,
That's good.
I did have one other thing. When Mr. Howard was speaking, he said there were 3 states. He didn't do it purposefully. I just think he would get around to it. The other one is Nevada. Nevada has registration with a designee. And then for Texas, their firm registration, the definition, I'm going to read it real quick. The definition for shorthand reporting firm that includes any business that partly provides court reporting or related services, including firm who contracts with licensee. No designated licensed manager for that firm. But, so we have looked at these, and we continue to look at these and try and mirror, of course, what works and whatnot. But I won't speak to the enforcement because I think you guys will enforce that.
Okay. So, yeah, I was just gonna say a couple things about, as a firm owner in California and having the ear of lots of firm owners around the country, that I believe Texas and Nevada have done a good job as far as at least slowing down, not stopping companies coming in, corporations coming in and doing things that are not legal in that state as far as court reporting services are concerned. And I'll stop there, but I know that firms are scared, or not scared, but they pay attention.
Yeah.
They don't just ignore the fact that there's firm registration in those 2 states.
I can tell you this, I have had so many firm members reach out to me personally. We have when you were asking about what would I do differently or what will we do, there is already a committed firm group, and the 78 one will be reaching out to you soon. But to get every firm owner, CSR licensed firm owner, kind of on a listserv so we can keep them all informed as we go forward with this bill and their input. We did have 2 firm owners come and speak. I'm not sure if it was at a hearing, but that it would be in their financial best interest to close their business here and open up in Nevada and then work here, let their license go. It's very concerning. So those statements, we will probably get more of those as we go forward. Well, I should say we will get more of those going forward because it obviously concerns the legislators.
Thank you for your testimony. Would any other person here like to speak on the matter? Okay, I would. Sure, please come forward. Welcome.
Thank you, Madam Chair. Good morning to everybody.
Would you like to say your name?
Yes, my name is Jennifer Escobar. I'm a freelance court reporter and independent contractor here in Southern California. I do mainly deposition work in the San Diego area, and I've been licensed for 2 years, since October of 2014. And I'm also here today as a future board member with CCRA. My understanding is I'll be sworn in at next month's convention, which I'm excited about. I just wanted to make a few comments as a licensed court reporter who does business as an independent contractor. I have one main agency I work with that happens to be court reporter owned. And I think we often refer to those as boutique agencies. They tend to be smaller. And my experience with that agency has been very positive and as well as profitable to my own advantage, given the money I spent while I was in school. But But I wanted to make a comment today that during the time that SB 270 has been on the table and the trade associations have been working on it, I've noticed that there has been a lot of support garnered on social media that gathered quite quickly once there was more attention paid to the bill on social media. I noticed several freelance court reporters took it upon themselves to spread information regarding the bill, especially any action that independent court reporters could take themselves to express their support. I think that that was a very successful part of the campaign. I believe that it was acknowledged as well by the legislature when it came time to vote, that there were letters and phone calls made, emails sent to our representatives to indicate that we as independent contractors and freelance reporters support the bill as well. I personally, since I've been in this profession, am very interested in being a part of change. I think that this is a very wonderful career to be a part of, a very lucrative one, and something that I thoroughly feel I was meant to do. And I just wanted to make it known to the board that I appreciate any efforts you can give to support us in this endeavor. It's going to be an uphill battle and then a mountain and then Mount Everest after that. But I, for one, am ready for the challenge and am willing to work with anyone and everyone that I can to support this initiative and to get this in place so that we have a level playing field for little old reporters like me who am interested in getting more clientele for my agency and doing well for them. So thank you for your time.
Thank you.
Sorry, may I? Ignacio Barba just asked if he could call in. He just wanted to respond to the answer of why SB 270 died if you were interested in it. I don't know how he would call in, so. Okay, fair enough. All right, thanks.
You know what, though, we can send his comments and ideas to the board in a memo, just like other folks have.
Okay,
Thank you. Looking at the time, I think maybe everybody could afford a comfort break, since there are no longer public comments. Good, so I'll close public comment now and take a 10-minute break. Sounds good? Okay. The time is, 11:15, okay?
Are you ready, Caesar?
I am,
Okay, wait,
yes.
we're ready? Okay.
One more minute.
One more conversation.
Okay, we're returning back. It's 11:15. We're on agenda item 5, discussion and possible action regarding statutory and/or regulatory violations by non-CSR-owned firms. We just finished up public comments, and now we can move on to board members' comments, ideas, discussions, direction. Would anybody like to lead us off?
May I say a couple things?
Absolutely.
Please.
All right, well, as I mentioned before, I am a firm owner in San Diego, and I have experienced different things that I think would help the board in this discussion. One thing is, I noticed after Mendoza 270 went down, the gift-giving model of doing business went on a rampage, and I believe that it's not as hidden as it was before, because I believe a lot of the companies think that they're safe now. So it's not even the gift giving under the table as much as it's very obvious. And the legal secretaries are the people who are telling you that. So go on. Number 2, I believe that Esquire suing the CRB Board of Louisiana for this reason, and I can't speak to exactly what the lawsuit is, but that's my understanding about the contracting and making Louisiana stop whatever their board is doing to keep the foreign corporations out doing business in Louisiana. I also noticed that some of the court reporting firms have decided to register their companies to come out of Hong Kong or Asia. Therefore, I don't know about the different laws that Mr. Howard brought up before, but I don't know if companies coming out of the United States, if this board would ever have any power over those companies. So that would have to be fixed. And I don't know, my belief is this subject might be one of the reasons for the impetus for these companies registering out of foreign countries to be protected from any type of regulation that the board might have. And so therefore, as I mentioned before, I do believe Esquire is suing Louisiana for a reason, the CR board. I know that Texas and Nevada, I've actually registered my firm to do business in Nevada, and I had to go and take a test to prove that I knew the Nevada laws concerning the duties of a court reporter and the services that I would have to provide. And I have to have continuing education every 2 years to show that I still know the laws of Nevada, and they are very strict with their enforcement. I don't know that they have a huge enforcement staff, but I know that they're very vigilant as far as making sure that not only firms are registered, but if a court reporter that's not registered or licensed in the state of Nevada goes to work in Nevada, they find out somehow, and they are vigilant in stopping it. And they even warn myself as a firm that's registered in Nevada, do not use these particular court reporters or else you will lose your registration as a firm. So they take it seriously, and I believe, because as I say, I'm on national association boards, that other firm owners pay attention. They don't pretend that those laws don't exist in Nevada or Texas or ignore them. And if they do try to ignore them and do business there, they are called on it fast, and they are sent a demand to cease and desist. And you can lose your firm registration status or your license status. And I know that I personally have to be the person who is responsible for my firm working in Nevada. And if they took it away, I believe I cannot do any work in Nevada, or I cannot produce any work that is under the jurisdiction of the Nevada case. So therefore, I'm saying in the long about way that firm registration, I think, is very powerful. And as far as Mr. Howard suggested, as far as having a licensee on the hook, someone definitely has to be on the hook. But my question is, would this board have any jurisdiction if these companies are creating their base in another country? They're working here, yes, but I don't know if that affects as far as the BNP code, the CCP, or the different laws that enforce or that corporations have to pay attention to if they work in the state of California. So those are my comments from what I've been experiencing in the world that we're talking about here as far as firm registration or anti-contracting or however you want to call it.
So just to underline what you said, this is more than just foreign domestic corporations. These are things that we actually talk quite a bit. It's foreign international corporations, and that brings in, that makes the circle much wider, and it means that our regulations and legislations need to be very tight and worded very well. So we're daylighting quite a bit of what we've been talking behind doors, and I appreciate the underlining of that. Are there any other comments by the board members? Oh, actually, can I ask you, we put Mr. Howard on the spot by saying, can you prioritize one or two things that you would like to direct the board to focus on fixing this issue?
Are you asking me if I
Now it's your turn.
Okay. honestly, as a person who lives this and has to compete in this market, and to be fair to the court reporters, I believe that firm registration would be one thing that we can do that's working in other states that would fix part of the problem. The thing is to have enough power. And then also, the only thing that I believe scares court reporters more than anything else is losing their license. So I don't know what it would look like as far as having a licensee being a manager of the company, but I could also see the company changing the licensee every month. Or finding retired licensees that don't care and putting them in that position. So it's hard for me to think, as we saw the pharmacy example Mr. Howard brought up, and I'm not sure, but it has to be something very powerful, that someone's going to lose something important, and I think it is they lose the opportunity to do business in California.
And again, like, it's important to note that the discussion that we're having is all about consumer protection, and so whatever route we take on addressing this issue is about protecting the consumer. And now licensees are obviously one of the many stakeholders in that picture, but we also have to think about all of the consumers.
Well, now that we're talking about it, and I'll just mention one other thing, and I've thought about this for many years, but I haven't. I believe if someone went to the Wall Street Journal or the New York Times and told what's going on in our industry, it would become a highlight on CNN because it hurts the consumers, it hurts the attorneys, the clients, it hurts everyone when the different things that are going on in our industry is happening, and a lot of it is under the table, is quiet, and it hurts consumers at a shocking level.
I agree.
So that's something that I would suggest if someone had an opportunity to talk to the Wall Street Journal, I think public opinion would be, people would be outraged.
Any other comments?
I'm relying on your input and other people's input. I don't have any direct input. But I was, somebody brought up social media. And I don't actually know how that could be pursued. But I think we need to be thinking along new lines if we're going to be, if what we've done before has not succeeded, somehow we need to be looking at the different approaches. I don't know what they should be.
So you're thinking education through social
Yes.
media to
Well,
them directly.
Yes, and if the public were more aware, as you're saying, of what's happening, then it's harder for the insurance companies, the whatever, to make false statements if we're putting out, if somehow correct statements are getting out there that the public can comprehend.
So you're actually talking a little bit about the future agenda item, which is our communication plan and education to people.
Because I don't know enough, I don't know anything about international trade things, I don't know where we step on those kinds of agreements that are already, I don't have the background, but I think we have to move somehow different, work on what we've got, but figure out better strategies or something.
From the things that you've heard thus far, there are one or two pathways for consumer protection that stand out to you as being important or will be effective?
Well, I do think we have to do the firm registration, and we have to somehow, somebody has to be in charge of, in a firm, who's held accountable.
Okay. So you do
That's essential, but how are we going to win the battle at the legislative level is kind of where I'm kind of concerned.
And we've also heard that CCRA is going to continue their
Yes.
270 fight with Senator Mendoza, which I think we all would like to thank Mendoza and his office for putting in a lot of work.
Absolutely.
How does the board feel about that fact? And what role do, if any, with CCRA do we want to play in them moving forward?
Well, sorry. I think we're gonna have to see how the bill's retooled, or assuming it's gonna be a new introduction of it, and see what that language is. You know, I don't think we can really say how we're going to work with it or not work with it or whatever we're gonna do with it until we see the language that is introduced. And then, you know, we go from there. My thoughts on all of this is, of course, bottom line again, it's always the consumer. And my thoughts on this is more of just sort of thinking out loud, and when I say things, I'm not really criticizing any particular person, entity, group, association. It's just sort of, okay, here we are now after all this. You know, I've been around for a long time, and I've been dealing with this for a long time. And, you know, as has been said, the real bottom line is the ability to enforce, and then even more importantly is for whatever the penalty is going to be, because if you don't have penalties to hold over their head, just like with the licensees, enforcement is not going to mean anything. You know, so we have to have something that would be very effective. And as I've been listening to everything, and as I've been thinking about this over this past year, what comes back into my mind is we need to be smart about this. And really, you know, and look, and I wish I could just now roll off a whole list of this is how it's going to work, and well, you know, we write off to the sunset with all language and everything's gone, you know, everything is, you know, put into place and it's all done with.
You don't have a magic wand?
Pardon? You don't have a magic wand. I keep looking for it and I haven't found it yet. You know, and you know, and how do we, you know, making sure we don't have these surprises? Like, you know, for example, when we had that lawsuit with U.S. Legal, that judgment about the foreign corporations threw me. I did not see that coming. And so that's where, you know, I think it's a good recommendation that we dig in a little deeper about, like, for example, Nevada and Texas are doing, and how they, you know, what they have found works in their enforcement and what hasn't worked to enforce what they have. And then the other thing that pops into my mind is we are such a small board and such a small staff. And as much as, and I'm not saying that to say this is that is a hindrance to getting things done. But I also am very pragmatic and realistic of how much can we dump on our staff and be effective. I don't want to spread the staff so thin, so I think for further conversation, we have to keep that in mind as far as what the best approach is, what is going to be the most effective approach. Because if we're, you know, using staff resources, we should want to spend it on something that we think is going to be the most effective. Right. And that's all.
Do you have any top 2 priority pathways, or? So far we've heard firm registration.
Yeah.
Is it definite? Is that a definite for you?
Yeah, firm registration, some type of firm registration in the sense of what will allow us to sanction if there's I'm going back to my Catholic school days, if somebody sins, you know, doesn't follow the regs, or doesn't follow the law. Again, you know, as I said, you know, you can come in and say, oh, we have all the statutes and it says, you know, you're not supposed to do this, but if we don't have that power to enforce and we don't have something that is going to make them care if we enforce it, then we're really spinning our wheels.
So you're saying power of enforcement?
That, well, power enforcement, but even more important, the penalty enforcement. You know,
All right,
something
power
that's,
is a penalty.
yeah, just, you know,
For registration with a strong penalty associated.
I mean, along the line of, you know, what everybody said here, starting with Ed, that when it comes to, for the licensees, I mean, everything that licensees think about is their license. I mean, I can't tell you how many times I have received calls from official reporters because, you know, we know about PROPERS, and of course, they file complaints with the court reporters, or another reporter will get a call or a letter, you know, saying there's been a complaint filed, you know, about it, and they're supposed to turn over your notes and, you know, the transcript and that, and they'll call me, I mean, just absolutely terrified they're gonna lose their license. So we need to have that kind of, I don't want to say terrified, but we need to have that kind of concern and worry on these corporations that you would think that everybody would follow the law because that's what you're supposed to do in this country. But, you know, we need to have something that has a little bit of weight behind it. And that's,
May I make one more comment?
Absolutely, please.
I know that the bar is really pushing ethics, and they force attorneys to get CE, ethic, continuing education classes. And I know DRA in the past had, they hired a law firm to talk about tax implications for the gift giving, who's gonna pay 1099s, or excuse me, the money that's being received. And I know that that was a big brouhaha for a while, but it kind of waned a little bit. And I don't know if there's any power, or if the bar would listen to us or listen to this situation, this issue, and take that under advisement, or to somehow chastise, or else help us, help law firms and attorneys understand what's happening, and therefore protect their own ethical issues, because in the long run, the gift giving goes back into the law firms because people are accepting gifts. And it becomes an ethical issue, and I think attorneys just are not aware.
Excuse me, Ms. Cranman, that relates back to the issue of violations by non-CSR owned firms in what way?
In the fact that it's basically, you give me a deposition, I'll give you a gas card. $10 a depot, $25 a depot, $100 a depot. And I have the evidence to show that that's happening. And so somebody is getting $10, $25, $100, but I don't know if there's anybody paying taxes on that income. I think we're rhetorical.
No, I think that's also.
So that's happening, and it's and like I said, and one of the reasons I know, since 270 went down, the legal secretary, Susan, and I don't mean to say, but some people are saying, golly, you are being a fool not using this firm because look at all the gas cards that I just got. And so as a person who is owned as a CSR, if I gave gas cards for every deposition, I would go for my $100 a year allocation pretty fast. And it's akin to bribery, which is an ethical issue.
Madam Chair,
Yes,
so I approach things very linearly, and I like to understand the steps. So I think for me, you know, the number one priority is making sure that these corporations follow the same laws that all the licensees have to. End of story, period. So, you know, including something, it would be a priority for me, you know, gift giving would be a priority, having them adhere to those same rules and regulations like you were talking about. I think having enforcement is something with teeth. If you aren't, and for registration. So if you're not comporting to these rules and regulations that we set forth, I am supportive of not allowing them to do business in the state of California. But I think, you know, your comments are very well founded. I think you're putting the cart before the horse a little bit, where I think we have to have these firms, us have the authority to enforce against them. But then once you do, you have to have the gift giving regulations right in place. And then after that, I think there is an opportunity, if we're able to enforce if somebody is in violation of the gift giving regulations, then obviously there is action against them. that's when communication, I think, with the state bar can come into play, because you have to have the regulation and then enforcement ability in place to be able to tell the lawyers, hey, FYI, we now have these new regulations, you can't accept those gift cards and those trips to Hawaii and Tahiti. It's an ethical violation on behalf of the court reporter. I don't think it's an ethical violation on behalf of the lawyer unless it's a law, it's a legally enforceable action. Does that make sense? So I think you have to have all these things in place before you can communicate and ask the state bar for help. But I just want clarification. I think that there are two avenues that we can go down, right? There's the regulatory action, right? And there's the statutory action. And everyone always says regulatory is always easier because changing a statute is harder, right? So I'm curious to know just input maybe from legal counsel or from my fellow colleagues here. Help me understand, if we assume the regulatory action, what are some things that we could achieve that we can't or can achieve statute-wise? And I also want to understand, if we go down those same parallel paths, are we hurting one path or the other? Are we helping? Are we making the statutory action, any 270, whatever we're calling it now, if it's reintroduced? Does that, if we impart on the regulatory side, do we hurt the 270 angle? So I'm just trying to understand all of our avenues.
Sure, so maybe it would be good to start with legal counsel on what it would take for a reg package, what it would take for legislative or statutory action. What's the process? You don't have to talk substantively, but what are we looking at having?
Well, for the regulation process, if the board decides to go that route, it would be to instruct staff to go ahead and come up with a regulation that would clarify one of the statutes in the Practice Act. And then staff will come back with the language for the board, and the board, if it so chooses, approves it, and then go ahead and authorize the staff to go ahead and start the rulemaking process. Okay. And once the rulemaking process is completed and goes through OAL and the OAL process, and at the end of the day it's published, then that regulation will be published in the California Code regulations, and then the board could take actions based on regulations against any entity that's may violate that regulation. In terms of the statute, again, the board has the authority to go ahead and instruct staff to come up with proposed statutory language. However, it seems fit to in terms of the language. And then staff will come back with the language, and once the board approves it, to go ahead and authorize staff to go ahead and find an author for that legislation and go from there.
What type of timeline would we be looking, just to give people a sense
In terms of
how long a reg package takes? How is it typically?
rulemaking process, package generally, after the language has been approved by the board, it goes through the process usually about, if I'm not mistaken, around a year. They have about a year from the time it's given to OAL for publication to when it's going to be approved or denied. So it's about
To resubmit it to
sorry,
OAL.
it's about a year.
Do you have anything to add to the question?
No, that's the regulatory process.
Okay.
Yeah, I just want to be very clear is when we're thinking about what is the board action, what things can we achieve and what can we answer through the regulatory process? What relief can we get?
Are you looking at substance on?
Yes.
Yes.
I know it's difficult because, we're jumping into presenting strategy to the other side. I think we have to remember. So maybe some more of your questions can be handled by the executive officer. So I think we should all be very careful how much we say about regulations and substance and legislatively and substance, because there's a huge team. I'm sorry to interrupt, but I can see why maybe we want to be very careful about what we say. Yeah.
Just wanted to point out again, as Mr. Chong, you said, it's only regulations of this board's Practice Act regulations, so we can't make specific other laws or statutes such as the corporation codes or any of those other statutes, we don't have the authority to define in regulation any malice law.
So there is a limit to what we can do with regulation. So the purpose of regulation is to clarify existing law. So we have to look at a statute that's in place, and it has to, as Paula just pointed out, it has to be our statutes. It has to be the court reporter statutes.
Okay, thank you. You have a thought? No?
No, I'm not sure of our current pathway. What are we trying to, are we trying to find a motion to direct staff to do something? Are we?
So right now, we're just discussing unauthorized or violations, unauthorized practice and what that means. Do we want to closely look legislatively, or do we want to take a path through our regs, just discussing in general? It's very difficult right now to discuss the options out in front of everyone. I realize that, and I think that's why we're kind of dancing around this. I think I want folks to know that we've been talking about this in closed session, and we're trying to daylight a little bit that we know this is an issue and we're working on it, and letting folks know what our main direction is. And it sounds like from the board right now, firm registration is strong. So that's one thing that folks out and about can understand. Now for me, I think the board should lead on this effort. I appreciate all the work that's been done by the various associations, but we are in charge, enforcement, mission critical to take care of consumers. And this is so innate in what we're supposed to be doing that for me, I think we need to make a decision on what we think is appropriate for all consumers and it not be led by industry and licensees. Now, what form that takes, does that come in a form where we partner? Absolutely. We should all be, as Board Member Chella said, we should be in unity. I completely agree. But the board should lead the effort. And we have been, as I said, it's been in closed session and now we're daylighting it. But now in a public way, in a very strong way, we need to move forward. And there's a myriad of options that everybody's talked about, legislatively, regulatory, and then many other options. And I see legal counsel.
Just to clarify, so from the conversation I'm hearing so far, it appears that the board is considering either legislative or regulatory action in terms of the issues of firm registration and enforcement. Is that
Yes.
correct? Or both?
Or
Okay.
both.
Or both, okay. I just more,
That seems to be the consensus that I hear. If the board member hears something different, please let me know. I think this has to be attacked on many different fronts. It's not one thing that's going to be the fix. We've talked about firm registration before. We haven't moved forward on it. And we're talking about it publicly now because we want everybody's input into the process. At the same time, we don't want to let everybody know, those folks out there who are indeed watching this conversation, how we're going to get them to not said. Thank you. And then I think someone else pointed out earlier too, I think it was Board Member O'Neill, that we have a staff of 4 people. And to combat the deep pockets of large corporations means that for consumer protection means that we have to be smart about how we move forward. And as everybody knows, we just went through sunset review, and that hasn't passed yet. And there's monies that we receive to help combat this, but it's not an endless pot of money. And so, again, I think the board is very committed to solving this inequity, and the public should be aware of that, but it is not an easy path at all. And it sounds like this is just the first of many, it is the first of many conversations we've been having. So if I could turn to legal and say, you've heard the consensus of enforcement and firm registration. These are all things we've talked about over the past year in closed session. How would you suggest we move forward?
I mean, in terms of the motion,
Well, not only just the motion, but just how will we accomplish exploring firm registration further and what that means in this public arena? And be careful.
I mean, obviously, one way to go is as to how we propose to form a task force to examine that. Two, another option would be to authorize staff to potentially come up with, to work with legal, come up with maybe some proposed language, bring back to the board, for the board to examine to see potentially what they will achieve, what the board is the board's objectives in terms of protecting the consumer. Those are the two options that I see so far.
And this would be both NREG and Ledge.
Right.
Or Ledge,
Or both, right?
depending on the instructions.
So for myself, I don't think that this is task force ready. In other words, I think the board needs to come up with their own position and their own fact and their own research. And I understand we have a very small staff, and there may be a point where we can have a subcommittee if people are interested of other board members to help staff with that. But I think coming to the table again with the associations, we should figure out and do our own research and not rely on industry and licensees to inform us on what is best. And that the staff, board members working with our legal counsel on formulating our next best steps would be my suggestion, and I would love to hear from the board what they think of that and how they would like to move forward, because it's clear that there's a huge issue. It's clear that we currently don't have the measures to enforce it, so it would have been done. This board is not at all a runaway board trying to do its own thing and not thinking about unauthorized practice. We very much are not happy about it and working on many different levels, but at the end of the day, it has to be enforced, and there has to be a penalty. And as things are written currently, it's not present. So any thoughts or ideas on creating a subcommittee, possibly working with staff and council to come up with what we believe is important to solve this?
I will speak. I would support Ms. Hurt's suggestion that the board take the lead role at this moment, because I believe we know things because we have been meeting in closed session, we have been meeting with council, we have different ideas. We also have a very strong opinion as to something needs to be done. And I think it would be beneficial in the long run to the industry associations as well as the consumer, for the board at this time with staff to spearhead what we believe is going to get us on the right path to solve this problem. And then I would ask for the support of industry leaders in the long run as far as what we believe needs to be done so that we have the power to enforce these laws. So I would speak in favor of Ms. Hurt's suggestion that we create our staff and subcommittee to resolve this issue.
Thank you. Board Member Lisinski?
I would be supportive of your direction there.
Is there hesitation? Sorry, is there hesitation?
No, I was thinking of, because you had said we're not ready for a task force, and I agree, we're not. And we've actually done the task force before.
Mm-hmm.
So, I think that whatever, we didn't get the results, and so we need to be looking more results. So.
Board Member?
Yes, I mean, I'm supportive with your proposition, Madam Chair. I would say that I think we have to develop our point of view where we feel like this board needs to go from an enforcement standpoint. I also want to be very clear that we can't, and I'm not suggesting that anybody on this board thinks that way, but we also have to be very uniquely sensitive to DRA and CCRA's points of view as well. And I think once we develop our point of view, I think we sit down with them and we develop a cohesive and united front, because from a timing standpoint, if CCRA is talking about introducing or reintroducing a new bill, that could happen between January and March-ish, or really any time. So, but I just want to be cognizant that I feel like the train is leaving the station a little bit on the legislative front with CCRA, and so I want to make sure we're on board and a part of that process. So I would ask if our colleagues would be okay with us asking Ms. Fenner to really sit down with potential CCRA and DRA, but also empower her to sit down with Senator Mendoza and his staff to really talk about what are some things that we would want as part of that language as well. And I know all this is dual track, but I want to make sure we're a part of that legislative process if we in fact have some things that we would also like to include in the bill.
So I completely agree with you that we need the whole industry associations, everybody working together to accomplish this, because one group I don't think can do it on their own. And we should be in tune with what's happening. And I think I heard from the president of CCRA with their bill that they're interested and willing to work with the board as well as DRA in accomplishing their task. So, was it Romeo? We didn't hear from you your ideas on the subcommittee, if at all.
Actually, I'm going to say, which I wish attorneys in court would say more often, I've listened to everything and I have nothing to say.
Okay.
Thank you for doing that.
So, that's funny. Okay, so
We need a motion to direct staff?
it sounds like at this point a motion, and then we also need to think about who would be on the subcommittee. And then also maybe we'll find out. I'm sorry, I see.
Subcommittee, I'm sorry, I just wasn't quite following.
So the initial proposal I made at the beginning there was maybe to help staff, there could be a subcommittee of board members that work, since we're such a lean staff before, to, as board member Nocella said, create our point of view and get that clear and succinct with legal counsel. We're not at the point of creating a task force yet, and that was definitely one of the options. But a subcommittee, and that's what I think everybody sounded like they chimed in, except for Mrs. O'Neill. You said you.
Can I actually, I just want, I have a question for clarification.
Sure.
When you are saying a subcommittee, are you defining the makeup of the subcommittee as made up of
Board
CRA
members.
members? So do we need to have a formal subcommittee?
Not if it's 2 or less.
Not if it's 2 or less.
Okay.
And then there's also an issue that I would like to find out from legal, if licensees are in the subcommittee, does that affect our discussion or taint it in any way?
I don't see why you would. I don't see any reasons.
Executive Officer Fenner, do you have any ideas or thoughts?
Out of an abundance of caution with what's coming out of North Carolina, I would hesitate to have the licensee members involved in this subcommittee as we're directing enforcement against a portion of, it's an anti-competition.
I think it's a good point. It's a good point.
So I'm having trouble hearing you, sorry.
I would hesitate to have our licensee members, as much as I would welcome their input and their expertise on this subcommittee, I think it would be better if they were not involved because there could potentially be a competitive element to the decisions that come out of that. And I wouldn't want it to look in any way that it was motivated by anti-competition versus protection of the consumer.
So I guess we already have our subcommittee members. Jackie, welcome to the board.
Subcommittee salesman.
So that's kind of where I think that would be my suggestion, and I'm one of many voices. So I will make the motion if you don't, no one thinks it's appropriate then.
Say what?
Does anyone think that it's appropriate for the subcommittee? If so, can someone make a motion so that we can, okay, she's working on it. Is this when I should play music?
I have another question or for clarification. If we have, are you anticipating that the subcommittee is going to be composed of more than 2 board members? Okay, in other words, yeah, that's what I'm worried about is the public notice right now. Because I don't think it would be beneficial for, at this stage of the proceedings, to be in a public setting.
Yeah, no, it's not. Not to get our point of view, and so I think Ms. Brady pointed
And
out.
I'm fine with it then.
Yeah, that only 2 board members can be on the subcommittee.
And the 2 board members cannot be court reporters.
Right.
Given that we don't know.
Are you gonna say no?
Well, why couldn't one of the court reporters who doesn't have anything to do with the freelance issue?
An abundance of caution.
I think she's smart. I agree.
And it still doesn't mean that you can't give input or let it be known what your thoughts and ideas are. It's just having the steering part in that committee.
Okay.
No,
Yes.
on that issue, that could, just, again, there's nothing, at least that comes to mind in terms of law that prevents a licensee from attending the subcommittee. However, if a 3rd member were to start communicating with the subcommittee, that would in itself make it a serial communications, which then means that you would be subject to the open meeting act requirements.
But the 3rd, or let's say, for example, it's Mrs. or Board Member O'Neill, she could speak with the executive officer about what her ideas are.
I don't see why not.
Or one member of the subcommittee.
But again, just
Yeah, please.
My understanding is that what I'm hearing from the board is that you would like staff to work with the subcommittee. We'll develop language to bring back to the board, so it's not like the board is not going to have input. So I just want to make sure everybody understands that we're not, the work of the subcommittee will not be the work of the board.
Yeah, they're just the workhorses and getting everything
We're
involved
doing
and
the
helping the
research.
staff.
Doing the research to bring back to you to make an informed decision.
And just to further clarify, is that for the purpose of both regulation and or legislation language?
And or, yeah, because we haven't narrowed it down yet, and the subcommittee will help us do that.
Okay? Yes, but she's working up the I think I keep trying. Are you ready?
Yes.
All right, I make a motion that staff and the subcommittee consisting of non-licensed CSR board members in conjunction with legal counsel will create strategy to enforce California laws for the court reporting industry.
Okay,
I'm
do you have
sorry,
a friendly
just,
amendment?
I just want a clarification in terms of strategies, coming up with proposed language to address the issue of statutory and regulatory violations by non-CSR owned firms. I'm just sorry, I just thought
I kept a generic strategy purposely, but if you prefer me to be more.
Do you have a suggested language after hearing all that we said to help us on the motion making? Is that what?
There might be more, maybe strategies including, I heard firm registration being a big point in the conversation. So strategies confirming legislation and or regulations, proposed legislative and or regulatory language, including regarding firm registration.
Well,
And enforcement. You'll get to talk
And
about
enforcement.
public comments.
I was actually thinking of just making it a little bit more generic, just having staff and the subcommittee work together to come up with proposed language, either statutory or regulatory, to address the issues of violations by non-CSR owned firms. But that was, that covers everything, so. But
She's
then
the
again,
motion maker, so
okay, all right, so again,
let's
this
see.
is just, okay.
Thank you for your suggestion. I saw you at the corner of my eye make the face, so I said.
No, I was just taking it back, sorry.
Okay.
I was not meant to make the face, I was taking it back.
Thank you
Surprise.
for helping us formulate.
Okay, I'll try again.
Okay,
And I'm keeping it generic and purposely because I don't want to put them in a box.
right.
So,
Can I stop you for a second? So are you going to take the motion away that
Yes,
yours was?
yeah. No one seconded it, no one cared.
Oh, okay.
All right, and so I'm doing this on the fly a bit. I make a motion that staff and subcommittee consisting of non-licensed CSRs in conjunction with legal counsel will write proposed regulatory, statutory language regarding enforcement of California laws regarding the court reporting industry in California. May I just say something before everybody says anything? Do I need to be putting in firm registration and all the different subparts?
No.
I don't think I do, and I don't think I should.
No.
No, again,
At this time, because I think that's part of the whole. Because I don't want to put everybody in a box here.
I think I would just make it the language broader so that,
That's right. So,
Okay, so I'm gonna ask you, I'm sorry, to repeat it one more time.
okay. I make a motion that staff and a subcommittee consisting of non-licensed CSR board members in conjunction with legal counsel will write proposed regulatory and statutory language and/or statutory language regarding the enforcement of California laws regarding the court reporting industry.
Great. Is there a second? I'll second that. Okay. Is there public comment? Yes, please.
Thank you so much for being here today and addressing this issue. I really appreciate it. And I really wasn't intending to comment, but something that Rosalie mentioned triggered something in my mind. Maybe one of the things that should be on the list in regards to gift giving is that some of these corporations are also giving away court reporting services and products at the expense of the court reporters. And I understand that that's on us if court reporters choose to work under those conditions. But the tax implications there and the harm to the consumer who is adverse in whatever action to the attorney who has now hired this court reporting service, who has promised to give away for free real-time services or only charge 1 instead of 5, or give away rough drafts in addition to the real-time, is harmful to the process because one side is being given something and the other side is not. And court reporters are being harmed, consumers are being harmed. And I hadn't thought of the tax implications of what happens when you haven't, as a court reporter, written off that you've given away services. Maybe you know you have, maybe you know you haven't. It's so murky in there. And if you're not paying attention to what you're doing and who you're working for, you could find yourself in a lot of trouble with the IRS, not only the CSR board. Thank you.
And Howard, on behalf of DRA, the motion's terrific. We were purchased. One thing on the tax issue, because it's first of all, that was a joint effort between DRA and the CCRA, both DRA and CCRA. Both conspired, were together, and paid for them. But the motion is terrific. We look forward to being helpful to the board as it meets this critically important issue. I can't thank the board for the chair.
Earlier, you wanted to say something related to.
Oh, yeah,
Is it related to the motion?
it is a bit. It's more related to council. It has to do with the regulatory authority that the board has. The board's regulatory authority is respectfully not limited to the business and professions code. For example, your standard of practice regulations are in part based on the code of civil procedure. The way that codes are organized, this is the fortuity, is decided in some way or another. Your regulatory authority is grounded in any statute that relates to the corporate profession. It includes the corporation's code provisions and its code of conduct, the business and professions code, and the code of civil procedure. And that's only related to the motion because it speaks to the wisdom of making it wrong. But we would urge your support. We can't thank you.
Thank you. So we have a motion, a second, no further public discussion? Any additional discussion on the board after hearing public comment? No? All right, let's take a vote.
Ms. Crum,
Yes.
Ms. Lisinski,
Yes.
Ms. Machado,
Yes.
Ms. O'Neill,
Yes.
Ms. Hurd,
Yes.
motion carries.
So that's the first part. The second part would be the members of the subcommittee.
Chair's prerogative to appoint.
Okay, do I need to do it in public or can I?
I think you've already appointed one if you want to.
I would like to ask Board Member Michela if she would be up for being on the subcommittee.
Yes, I will.
Okay, and can the chair appoint herself to the subcommittee?
Thinking why,
Is that a yes?
I would appoint you if I could.
Is that possible?
I think so.
Okay, so the two attorneys on the board here will team with the other attorneys here, as well as the staff, to make this happen. Okay? Is that okay? Board Member Lisinski? Yeah.
Oh, you think it's totally fine with me?
Okay. I'm thinking of you.
Okay.
You already have a task force, which I heard went really well. We'll talk about it everybody says. I'm gonna make sure that that's everything we need to do related to that issue.
I think so.
Okay, all right. Good, so we're coming up on 12:10. Can folks power through a little bit more for lunch, or
Yeah.
should we break?
Let's knock it out.
Yeah, well, let's get it done.
Okay, all right, moving on along. Let me just shift some of these papers off. If we now move to agenda item 6, it's report from our executive officer.
So if everyone wants to go to page 38, you will see where budget-wise the board ended up at the end of the last fiscal year. If there are any questions, I can answer.
I always have questions, but I'll see if other board members have
Questions on the budget, they're scary, no.
Any other? Okay, I'll start. Okay, could you speak a little bit to line item IA with OPS? And explain?
Yeah, IA is an interagency agreement, and OPES is the Office of Professional Examination Services. And so we have an agreement with our sister agency to help us facilitate our exam development workshops. So they're the ones that help us with our written exams. That's the English portion and the professional practice.
Currently on the, I just want to point out, and maybe you can do so better for our board members, the projections and how it says 0 in the governor's section and 38, and then has it all been spent? Just exactly where are we with that?
So just so everyone knows, the line item where it says governor's budget, I really shouldn't have that put on there. It's really something that the accounting and budget office uses to help them develop the projections for us as kind of a starting base, but it's not very relevant as far as the board evaluating where our expenses are going. As far as the difference between the what we spent last year, the first column where it says actual under 14-15, that's what we spent in the last fiscal year. In the current fiscal year, you can see it's quite a bit higher. We did receive an increase in our appropriation so that we could write additional test questions. We were finding from the results of our exams that it was likely that the exam, while not totally compromised, probably had stale questions. And so we did receive money and we had additional workshops. so that we can write additional test questions.
Okay. On the CRP fund,
If I can just get us there quickly, on page 39, that is the start of our budget for this year. We're very, very early on in that budget process. So basically, accounting took last year's figures, kind of raised it by 2%. So these are very generic. As we get into actual expenditures, then that will refine, and you'll see those numbers kind of rearranged to where the board wants us to focus on for this year. So I just wanted to point out that that's very broad-based at this point. And that does bring us to the fund condition on 40. You had a specific question?
yeah, just, I think for benefit of new members and also the public, if you could just talk about the months in reserve, some of the reasons why we look for a fee cap increase, and just a short synopsis of where we are, where we're going, what's happened.
Sure. This is kind of the board's savings account. This shows what kind of general fiscal condition that we are in based on accounting's best numbers that we give them. We work with them on this is how much we think our revenue will be for these future years. This is where we think our expenses will be. And so this is our best projection for you, the board, to see this is where we're going to be. We don't want it to be super big. We don't want a huge, huge reserve, because that just is collecting dues or fees from the licensees unnecessarily. But we want to have enough of a fund so that we can respond to issues that we need to resolve. In particular, if you look under budget year 17-18, you'll see that it falls below a 6 months operating reserve. That triggers something for us that's unique in that the transcript reimbursement fund is funded through our main fund here. And once it gets below 6 months, we are no longer able by law to fund the transcript reimbursement fund. So this is a triggering point for us to look at different ways to increase that so that we don't endanger the transcript reimbursement fund. Specifically, we would be looking at raising license fees. In the past, the board has talked about the different issues that we have. What are different ways to make this come out positive for us? In the lean years, we have basically cut every possible way that we have cut, down to even having a meeting once or twice a year. So I don't really see any places we could cut, but we're always open to, if you think there are places we can cut our expenditures, we're always open for that. The two places we can increase revenue is to increase the costs or the charge that we give for the license testing. So that's a relatively small pool, and that's capped at $75 per section of the test. So we could increase that. It would be a burden on the students, and it would be of limited use. And then our only other option is to raise the license fee. That would be spread across 7,000 licensees rather than a handful, maybe 300 or 400 candidates. So that really would give us the most options. What I would recommend is at our next meeting, we'd work with our budget analysts to prepare some different scenarios for the board's consideration so that you could take a look at if we increased the exam fees by X amount of dollars, this would be the difference in our months in reserve. Alternatively, if we increased, say, by $20 the license fee, how far out that would take us and put us in a secure position. So that would be my contemplation at the next board meeting, that you would have those specific figures before you.
Okay, I appreciate that. I think it seems in the budget 2016, 2017 had to figure out and have something in place, so we need to be reviewing that sooner than later. And the next board meeting sounds like an appropriate time to start gathering facts for that. Okay.
And then on page 41, it's just the same type of general overview of the transcript reimbursement fund. And you will see that going in at the money going in, the money going out in the form of claims. Paula, would you be willing to give us a little update on where we are with the trend, since the TRF is totally in your hands right now?
Yes. So as a result of that, and a number of other factors, including the volume of meetings we've had in the last year or so. We have about a 5-month backlog on the pro bono program. We are, however, processing the applications as quickly as we can. So we currently have already approved this fiscal year over $90,000 in invoices. That's 163 invoices since July 1st. So last year, there was a dip in the amount that we processed, not the amount we received. But we have been inundated with pro bono applications, and then on top of the additional workload and so forth, it has created quite a backlog in application processing. ProCur stands as usual with the money having been allocated. We do have a little bit of money left that we're waiting to allocate when we get answers from some applicants and or court reporters to finish up those applications. So as we come to the end of this calendar year for that program, all that money's been spent. We have over 80 people waiting in line for next year.
Do we have any money for an additional half-time person?
Yes, and we are pursuing the authority to hire.
Okay,
That's in the process.
that's in the process.
Yes.
Okay. Well, thank you, Ms. Britton.
And starting on page 42 through page 47 are the historical exam pass rates. If anyone has any questions, I can address that.
I have a comment. I was noticing 152 test takers and 106 returning test takers for at least the second time. Any comments on why that is that way? What you've seen?
I think that it's difficult to have any control over the candidate once they take the test the first time. I think they come to the test the first time, fresh out of school, they practice very hard, they're at their peak performance. And I think that, as clearly shows by the statistics, that is their best shot at passing this exam. After they pass that test, I think it's quite common for the candidate to say, yeah, well, I passed school, I'm done with school, I don't need to practice. And so I kind of equate that for people who are not court reporters and have been through it. If you think of it as a race, as a marathon, if you're a runner. So you practice really hard, you come to the test, you run your race, and you didn't win, so you're gonna race again. So you wait 3 months and you think, oh gosh, I've got another race coming up next week. I think I better start practicing. I think I better take a run or two. You're not going to be at your peak performance. You have very little chance of passing that test or winning that race if you're not training all the way through that period. So that's what I believe is the problem. But we have no control over that candidate. All we do is suggest to them, if they, in the letter that notifies them that they have failed to pass, that it would be to their advantage to find some sort of practice program, go back to school, whatever they're going to do to prepare, but you have to do something. You have to do something.
And may I say, I had the privilege of speaking at Sage College graduation class a couple of times. And the school talks about this and gives opportunity for people who have not passed the first time to come back, and they emphasize, please come back and practice and don't wait. So I believe the schools also acknowledge that and are trying really to help encourage students to come and to keep practicing, because that really is the key to success, is passing this test.
And that was Sage School?
Correct, Sage College Court Reporting.
Thank you.
And perhaps all the schools do the same.
I believe so. And if there are no other questions, page 48 and 49 are the end of, like, the wrap-up of last year's complaints, and then page 50 and 51 are kind of the first quarter of this new fiscal year. And if I can answer any questions on that, I would be happy to.
Did I notice that these were the fewest complaints sent to the agent's office this past year, this year?
Yes, so the complaints that go to the Attorney General's office, we issue citations and fines from our office. Anything where we're looking for revocation of the license or something much more substantial goes to the Attorney General's office. So that's a little bit random. We have really no control over what complaints we get or how serious they are. So the numbers that you see here don't really reflect any type of trend as far as up or down in numbers.
We'll try to. That was my question. Great, okay. Any other questions from board members? Okay, so,
There's one more item.
one more.
Yeah, it's actually on page 52. This is a letter that we wrote to the Department of Education to, in support of continuing the accrediting body ACICS. They had till yesterday to find out or make a ruling on that, and they did. The Department of Education did decide to not recognize ACICS as an accrediting body anymore. And so it's my information that ACICS intends to appeal that decision. So they are in flux a little bit, but this will be of major import to all of our private schools that are accredited by ACICS, because if this goes away, they would be on the hook to find another accredited body, which is not easy and it is not inexpensive. So I will do my best to keep the board up to speed on what's happening with that, but it's a little bit in flux right now and it is being appealed.
Yeah, I know the board, we wrote the letter on behalf of the board about how this deeply affects court reporting when filed to private schools. And that's what 71% of court reporters that come out of these schools now are not accredited. And it's more than just money, it's lives, it's complete disruption, and it'll have a domino effect in the system, the judicial system, as much folks that can get out and be workers there.
May I make a suggestion that if we can reach out and if there's any way that we can help in the appeal process, keeping the ACICS accreditation, I would offer that as from this board, whether it's a letter in support. I don't know if there is anything we could do, but like an amicus brief of working court, if we had any power.
So, as I understand the process at this point, they have 30 days to appeal, so they haven't technically appealed yet. So perhaps a letter would be the right approach at this point, if that's where the board wants to go.
Is there any research that our legal counsel has done about how this will affect the board? Did I hear that? No.
Well, I mean, because right now, ACICS has expressed its intent to appeal the decision. So as it stands right now, everything stays the same, pending perhaps of that appeal. So immediately right now, there's really no effect.
So it's all like a stay.
Right, exactly.
And how long do we have that stay?
That I probably would need to find out.
Assuming they appeal, it would remain in effect until there was a decision, one way or the other. If it was adverse, there may be judicial remedies after that. But as I understand, there's no timeline for the decision on appeal if they do appeal, and then they have 30 days to decide or to actually.
There's kind of a different layer as well. So they'll have a grace period also if the recognition is completely pulled. The schools will have a grace period. So there's, I believe, 5 of our schools that offer a degree program, and those are the ones that are affected by the decision. Also, it can affect the financial aid for the students. But there's also the layer of the Bureau for Private Post-Secondary Education, who they're also approved through, which is state level for the private schools, and they offer 2 types of recognition. One is a simple one. If you already have an accreditor such as ACIS, then you just have to do a simple accreditation through BPPE. And then there's a full accreditation that you can get for BPPE, where you have to go through like their whole program to be recognized by the state level bureau. So they have some other options if the ACICS is completely pulled. We're following that as well.
I think board members, I would say that to follow up on that comment, that BPPE's website, which is bppe.ca.gov, has its own link dealing with ACICS that has quite a bit of good information on it.
So if there are any public members out there that are concerned, they can go to this link to find out more information. Of course, call the board, but so far we're at a 30-day stop, and more information will be coming. Okay, are there any other questions on this agenda item?
We have further school update regarding
Oh, actually, set reviews. I'm sorry.
set reviews.
On-site meeting.
Yeah, we let the stop or second up, I think board member Crom suggested that we write a letter.
Yeah, I think
And so, is there, yeah, I'm going to put her out for 1 second. But I came back, and what happened? So would you like to make a
Well,
motion?
and I would ask council, when is it appropriate to write the letter now or to wait till the appeal happens?
I would say now.
Now.
I mean, so
It's
that
timely.
they can have it, right? Because we don't, I mean, yeah, they have 30 days to appeal, but I don't see the harm in doing it now as opposed to waiting.
So the motion would be to write a letter,
In support of
in
the
support, right, in support of ACS.
To the Department of Education.
I would
Is
think
that
that.
going to be different than the letter you already made?
Yeah, I know. Can they use it, can they use our letter? Do we just put a new date on it?
Say that again, I'm sorry.
This is dated August 5th, and as of yesterday, it came down that they're going to lose their accreditation. So I wonder if we just write a letter dated September 24th.
I mean, it might be, as far as time consideration goes, since there's technically nothing pending before DOE, as far as appeal goes, it might be more appropriate to hold that letter until there is something pending before DOE, but if the board is eager to get out in front and make its news known, of course there's nothing to stop them from submitting that letter now to DOE. And maybe making it, I'm sorry, maybe making it some wording to the effect of in anticipation of the appeal that would be filed by ACS. Yes, we offer these programs.
Do you think that's helpful?
I don't know. I don't know the answer to that
I
question.
don't know that.
So one thing, when Yvonne and I worked together on getting this letter out, it was pretty fast turnaround. And so for me, I think it's lacking a lot of statistical details that they should be aware of. I don't know, we keep asking the staff to do more and more. I appreciate the motion or the possibility of a motion to write a letter in support. I think it's a good thing, but timing wise.
Maybe we just wait until the appeal.
So would it be a motion to?
Because if they don't appeal, then we're wasting time to, I'm assuming they will appeal, but if they don't.
They have indicated they're planning to.
So should we make, no?
We can deal with it.
We'll deal with it.
Okay.
I think that we can clearly hear the intent from the board, so I think that will help us.
All right, then that's good.
Okay, let's just see what happens. All right, everybody's heard about that.
Thank you for listening to me.
Absolutely. Right, and then there is a follow-up screen of something that we were leaving off.
Are you recording on that?
Would you?
Oh, sure. The board has requested information from 2 schools in the Bay Area that we will be going to and visiting the second week in October. So we've collected information from them, and we have employed our consultant that we reported on at the last meeting. Mr. Ned Branch has been reviewing said collected information. So we will be conducting those site visits very, very soon.
Good.
Thank you.
And that concludes the report from the executive officer.
Okay, thank you. So we will move on to agenda item 7, the online skills exam. In April, there was a presentation to administer the skills portion online through a third-party vendor, and there was maybe one dissenter, but some dissent. However, the board voted to go forward with a task force that was chaired by board member O'Neill Lazinski on April the 9th. Would you all like to talk a little bit about the task force, what you'd like us to know?
Certainly. So on September 9th, task force met and in Sacramento. And again, I would like to reinforce the idea that we have not decided that we are not going forward with the online skills. We are looking into the policies and procedures that would need to be in place should we move forward. So I think we made great progress. We need at least one more task force meeting somewhere in Southern California.
Do you have other things to add?
Yeah, I think, it was facilitated by Solid, which really, I think, got the group to focus and be productive. And it enabled us to look at the whole process and to start creating, I don't want to say a formal document, but sort of try to determine what questions there are out there about this process. What might it look like? What might be the problems? How do you deal with certain issues so that when it does come before the board for a decision on whether or not to move forward on online testing, at least for the board members, if they have questions, the hope is that this task force has already addressed that. And this is what the task force's response is to that issue. And not saying that the task force has solved all the issues, but this is their response, and it'll be up to the board whether that's a good enough response or it's satisfied that. I found it very interesting in that with that many people and having been subgroups, that each group tackled a certain issue of the testing, of what might become the online testing process. And dealing with people from the schools, we had licensees, we had students, Elizabeth and I can't remember who else. We had students, we had
Testing.
and then somebody from the testing agency or bureau was there. Yes, was there? Wasn't she?
Oh, yes.
Yeah, that's who she was from. But there were very valid questions. It definitely made everybody think about different scenarios and what might need to be done and how to approach it. So I think we are going to meet again in Southern California, just based on the information that was generated out of this first meeting. I think it's going to be very useful to the board in providing information to the board members as far as coming to a decision either way on this issue.
Were there one or two items that popped up that were surprising for you all that you'd like the public to be aware that with that task force?
It was more of I think one of the things that was really surprising for us is that we were talking about how long it's going to take to process, once they take the test and, you take the test right now, in a hotel room, and then you get so much time to transcribe it. And a discussion came up about how long should that be, with it online, which then generated to, okay, it's 3 hours right now, but then the discussion said, well, is that really too long even as is? Though? Because, one of the things that the test is supposed to do is supposed to reflect what's going on in the profession currently. Is it really, is it realistic that reporters shouldn't be expected to transcribe 5 minutes of testimony, that it should take them about 3 hours to do? It helped us not only look at what may be coming down the line, but it made us look at what is currently being used in the testing process. And I think that was valuable because of the fact that, the test is an entry-level test. It's supposed to reflect what an entry-level reporter is supposed to be doing when he or she gets out in the field, just like they cannot use typewriters anymore to transcribe the test. They use computers. And that part of it was was very interesting, and it brought home to me at least how much we really have to keep on top of that, because our field changes all the time, and we need to keep on top of what is the standard practice from year to year to year, and make sure that our testing methods reflect that standard practice so that the consumer stays protected.
Anything to say?
So, part of this, if we would go forward, there would be a certain overlap between the currently offered in-person exams and then the online version. And so, we were informed that whatever you do for one exam, one form of exam, you have to do the same guidelines or procedures have to be in place for the online as well. So however much time is allotted for the transcribing, whether it's 2 hours or 3 hours, whatever is offered online has to be offered in person and the other way around. So we can't have two different sets of procedures.
Okay, so very fruitful task force, and there'll be another one in Southern California. Sounds like the plan moving forward. Are there any public comments or questions? No? Any other member? All right. So that will take us then to.
I do have a quick update on the OPES audit. OPES has determined that they do not need to audit this portion of our exam, this portion. So that is not something that will be followed up on.
Okay.
I would give them a quick plug though. They were very kind in attending our task force meeting and really helped us greatly. And while they will not be available for the Southern California meeting, they made themselves available if we have questions, and they will be happy to review any of our work, which with their great experience would be really helpful to us.
Okay. Agenda item 8, strategic plan, update on action plan accomplishments. I think it's good to focus our time on target dates that are this and next year. Do board members have any questions about where we are, where we should be? Any comments?
We've done a great job.
We'd like to applaud ourselves.
Yeah, but I appreciate it when you come up, and I know that from social media, that the different best practices when it comes to exhibits and videotapes and core and the things that we're putting on our website about the working reporter has been really beneficial. I know that's come from this board and different task force and groups, and it takes time and effort, and it takes some industry knowledge. So anyway, I applaud the fact that we've done that and that we stayed on task and put together some really valuable information that's on our website that helps the reporters do their job. So I applaud you all for doing that.
Yeah. I think I have just one question, just kind of how we are with the cross training. It's December 2016, January 2017. Here we are, 4 staff members. How's that going?
We are on track to have it completed by that time.
Okay, that's good enough for me.
Okay.
Okay, check. Some other items. Someone brought up earlier about continuing education and that being mandatory. Right, and I think we've heard before about education to different folks from the board. I just want to make it clear that we put that to the governor and veto that. So it's not something, we may in the future want to come back to that, but at this point. I'm sorry?
When there's a new government.
Yeah.
It's a different political atmosphere.
Maybe, maybe not, but it's been vetoed, and so that's been done. Check. Another item that I want to point out that's on here is research real-time captioning standards and assess industry practices from the board to evaluate the need for consumer protection. I've had the opportunity to talked to a couple of folks about its importance and growing importance in the industry, and the need for the board to think long-term what that means in regulating, especially for folks who are hearing impaired, etc. I don't think we're ready yet for a task force, and believe me, we don't have the bandwidth for that. But I would like folks to think about how we're going to grapple with captioning and CART and the standards, how we can fit that in and prioritize. It has a date of September 2018, so obviously we're not going to be able to jump on that until 2017, but it's around the corner and it's happening quickly, fast.
I would just like to let the industry know that we're very much committed to that deadline, and we will be reaching out to stakeholders so that we can start gathering information. It will probably be after the first of the year, just to kind of give you an idea, but that's very much, staff is very aware that this is important to the board, and it will not fall through the cracks.
And I would say that I've spoken with some of the industry leaders in CART and captioning, and people that actually want to be involved and help us create standards, because it's so important and it's a fast-growing industry right now. And so I think we're going to have a lot of support from state associations as well as other industry leaders in this arena. So I look forward to making something happen.
In fact, I see in the audience here a leader, one of the leaders in CART and captioning, Seba. You have to remind me your last name. You have such a beautiful first name. That's all that I remember. That's all you need.
McKinley.
McKinley. Would you like to make any public comment to that effect?
Sure.
So I spoke with Mrs. McKinley actually yesterday, in fact, about captioning and CART standards. And if you could just give us a really brief, because we do have a target date of 2018, we won't really get into the depths of it, but what you see right now and what you would like the board to be looking out for in the future.
Okay, I'll try to see if I can be succinct. I spoke with Ms. Hurt last night, and I told her I've been involved in the industry for the past 6 years, and deeply involved, so much so that I've written a book to help people get started with it. It has become a part of the California Court Reporters Association because I felt it was something that was really important, and I brought it to the board when there was time for nominations in 2013, and that was my focus was about captioning, because I've been a reporter since 1991, and so the majority of my career has been as an official court reporter. But for the last 6 years, I've been working also as a CART captioner. And it was as I was sitting next to other captioners, because we team, if the class, in classrooms, if it goes for a certain amount of time, they just put you on as a team. So I would see other captioners coming in, I would be looking at the screen, and the quality of what was being produced on that screen was a problem for me. I said something needs to happen, something needs to address that there's no standard or a guideline or licensing or anything for someone coming out and providing this service for a body of people who are really relying upon it. The California Court Reporters Association is in an alliance with the Hearing Loss Association of America, and they put on a walk for hearing every year. And our team, we raised the most amount of money for the walk class, not last year, the year before last. And I just wanted to share with you the mission statement of the Hearing Loss Association, as well as the number of people who are affected by hearing loss, and why this is so important that this body of people are protected as consumers. The Hearing Loss Association of America is the nation's leading organization representing people with hearing loss. According to the National Center for Health Statistics, 48 million, 20% of Americans have some degree of hearing loss, making it a public health issue, third in line after heart disease and arthritis. And the Walk for Hearing, their mission statement is, the Walk for Hearing is a walk to raise awareness about hearing loss. help to eradicate the stigma associated with it, and to raise funds to provide information and support for people with hearing loss. I am the captioner for 2 Hearing Loss Association chapters here in Southern California, Orange County, and also in Long Beach and Lakewood. So I'm very aware of what they are trying to do for individuals with hearing loss and why captioning is such an important part of that. So I just think that's really important that we have some standards that are set in place that can help guide us with that. And as I told Ms. Hurt last night, that it's not even going to be a reinvention of the wheel, because there's a state that's doing it very, very well, and we have access to how they're doing that. I furnished her with a copy of the Massachusetts Commission for the Deaf and Hard of Hearing. They have an actual commission in Massachusetts, and they put together a quality assurance program, and I shared that with Ms. Hurt last night, the quality assurance program, as well as the ethical conduct. There's something that's already in place. So, like I said, we don't have to really try to reinvent the wheel. It kind of felt like that for me when I first came to the CCRA, because there was nobody else on the board who knew anything about captioning, and there were some members on the board who had taken the exam that the National Court Reporters Association puts on to get your certification as a CART provider, is what the name was then. It's now CART captioner. But there were members on the board who had taken that test, and they said they would have no clue of how to work as a captioner, even though they had this certification saying that they were certified as CART providers. They would not know how to work in the environment, and it's because I came from court reporting into the environment of CART that I knew that it's a very different environment. What your screen looks like is different. Having the ability to know how to change your font, how to change your background, how to go in your software and be able to do that, and that the consumers have different limitations, and you need to be able to address those limitations. And so the schools were not even addressing that. Schools are teaching students how to work in court or in depots. They don't really train you as to how to be, at least the schools that I attended and that I'm aware of in Southern California, well, I guess in Northern California too, are not teaching. They're beginning to now. I should stop saying that. They're beginning to now. When I first started talking about it in 2012, they weren't. But now it's come to the attention. CCRA has had captioning as a part of its convention for the last 3 years. So there's more awareness about it now, and people are interested. Court reporters are interested in transitioning.
Well, thank you for passing on all the information you did last night, and I'm sure the board is looking forward to hearing more and more as the time passes.
I would like to say something on behalf of the consumers of the captioning. So I am in the demographic, hugely, that requires that kind of captioning, and I can tell you how important it is for people who live near me, people I know, and if they're not getting a quality product, they've lost. I mean, that kind of captioning happens in all kinds of places, needs to be in more places. That if they're not getting a quality translation, they've lost entire history, information. It could be important to their health, their well-being, their
safety.
Yes, exactly. I mean, it pertains to so many places, so I applaud you and I thank you. So
Yes,
please pursue.
I just want to add two things if I can, just to keep you in the loop. One is we made a resolution to NICSA, which I don't know if they accept those anymore, but I talked with Dave Winnold, their lobbyist, and with their in-house lobbyist. It was Adam Finkel, but now it's someone else. I talked to him just recently, and we proposed the caption be covered under Medicare for doctor's appointments. So I want you to know where we're going here.
Right.
It's big time. And then the other thing is to keep you in the loop, and of course we will, but we do plan on introducing a CART bill this next year. We already have an author, and it's to include CART providers under the interpreter statute in court. So it's two distinct jobs, but we just want you to be aware of, what we're doing and where we're going, so we can all, work together, of course, and be in line and in step. Okay?
And I just want to add one last thing. At our convention last year, I invited Ms. Finner to come to one of the seminars that we had because there was a panel. I believe Ms. O'Neill was there as well. But there was a panel of consumers, people who use the service, as well as homeowners who are who have cashiers working for them. And I think Ms. Finner said that was quite informative.
Absolutely.
Yeah.
And before I forget, I'm gonna say every time we talk about carton cashing, one of the ideas brought up that I gotta make sure we include was that as we have the TRF, is to have some sort of fund for the poor hearing as we delve into this.
Okay.
That didn't come out right, but I hope you know that.
Yeah.
And I want to say one more thing on that too, because the walk for hearing is a great place to start for that, to have a place to have a reserve of funds, because that's what we're doing with CCRA. We actually have some funds that are set aside that we haven't done anything with yet for the last 2 walks that we had, because 40% of what you raise comes back to a nonprofit, which CCRA is a nonprofit. So when we walk and we raise the funds, 40% of that comes back, and it has to be used for captioning services. So if someone were to, we haven't set anything in place yet, but if someone were to approach CCRA and say we'd like a subsidy for servicing a medical appointment or something, they wanted to be able to use those funds, we actually have some funds.
So thank you.
So we have lots of knowledge we'd love to share with you.
And you should send that to the board, all the information that you have, because the guidelines and ethical ways of doing that would be really important for the future.
And I shared with Mr. We'll share with you, we are collecting and have been collecting consumer harm from the consumer to let us, to help you when you eventually get there. We would be working together.
Thank you. One last comment, or your
No, I just,
okay. Thank you very much, ladies. All right, any other comments on the action items or points? No? Okay. Does anyone need a comfort break?
Yes.
yeah.
Should I hear a yes? Okay.
Yeah.
So it is 5 till 1, let's come back. 1:05, is that good? Are you ready? Welcome back, everyone, to the Port Rivers Board meeting. We left off just talking a little bit about the strategic plan and giving an update on what our action plan accomplishments are. We have board members that will have to leave in a little bit, so if I could rearrange some of the really important items, is that okay with the rest of the board members? Yes, please. First, election of officers. I think we could take care of that and get that out of the way. Every year, like you remember very quickly, we re-elect board officers because it's on an annual basis. This is the first regular meeting of the board after June the 1st of each year, which would be today. So I would just like to confirm what folks are thinking on who the officer should be. Currently, I'm the chair.
Would you like to continue?
I would like to do too.
Because you don't want her to. That's what I thought, but I wanted to confirm that.
I would like to nominate you to continue as chair.
Is there a second? I'd like to second that, please. Okay. Are there any public comments? Mr. Howard, would you like to start?
I'd like it, if it was appropriate, to do a wave by myself.
Okay. No further discussion. We'll take a vote.
Ms. Cronk?
Yes.
Ms. Lisinski?
Yes.
Ms. Noshella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Thank you. Okay. And then moving on to the vice chair, board member Cronk is our current vice chair, and I would like to know if she would like to continue.
It would be my privilege.
Wonderful.
Then I would like to nominate.
You're welcome. You make the motion.
I will second.
Great. Roll call.
Any discussion, public comment?
Oh, sorry, public comment as well.
All right, Ms. Crum,
Yes,
would
please.
you like to vote for yourself?
Yes.
Ms.
Yes.
Lisinski?
Yes.
Ms. Michela?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurd?
Yes.
Motion carries.
Wonderful, thank you. And then the second item, we'll just jump right back. Let's see, actually it's agenda item 9, discussion and possible action regarding the communications plan. So one of our strategic plans early on was to better communicate with consumers. And we received a very broad overview of our goals and plans and who the audiences. And was it the last meeting or the meeting before? Now they've narrowed it down and created a timeline. And it's just a draft. It's a CRB communication plan timeline where we're talking about social media. So as someone talked about earlier, using that more. And also working on our website. I think the plan has definitely evolved from that March plan. Actually, it was March. So, are there any comments by board members on what they've read, seen, ideas or thoughts?
I have a couple comments.
Please.
There's a couple places where they have, where they want to put things on Facebook that I think would be better suited to be on our webpage. For example, right off the bat, the first thing versus Facebook campaign highlighting bullet points about the complaint process. I think when it comes to the complaint process, the people, where they're going to go is they're going to go to the board's website and look. They aren't going to look on Facebook. And so in fact, I know for myself and others that if somebody has a complaint, I refer them to the website. And I think it would be very helpful on the website for there to be a very similar to a bullet point, very succinct, do this, then you do this, then you do this. Very, very basic and clear how you follow the process, because with ProPERS, for example, you're dealing with all sorts of comprehension issues.
Okay.
And so I think the consumers would be better served with that kind of thing on the webpage versus only putting it on Facebook.
Okay.
Or first putting it on Facebook.
So I kind of agree with you similarly. The website needs to be addressed first before we trailblaze a social media campaign.
Correct.
Because then will that go to the website and say what? That's supposed to do.
Yeah, and I think the problem with Facebook also is that you get into, people can post comments. And I've seen people hijack, on Facebook page, topics, etc. Whereas on the web page, I think that's where you go when you want information. And so that's why I would like to go through these and, I didn't notate all of them right now, but there was a few, I remember thinking to myself, there's a few of these that I would suggest that they be directed toward the website versus the Facebook page. Does the board even have a Facebook page?
No, if I could clarify, I was going to clarify that for the benefit of the
No,
we do not have a Facebook
We do,
page.
I don't know about it.
We do not. So part of this is the creation of the
Oh,
Facebook
I see.
page. OPA would be, the Office of Public Affairs would actually be the people that would be updating it for us. We did express concerns about opening up comments, and that would not be the appropriate place for us to respond in that thread to happen. So it would be contemplated putting up as a post only, so it's information out.
Right.
There would be a way possibly to get information in, but it wouldn't be a public posting. We would be able to get that information via the Facebook portal, but it wouldn't be open for public comment, so to speak.
Then I would suggest, in that case, I wouldn't be as concerned about having Facebook presence. But what I would suggest is it be in both places.
Okay, okay. Well taken. Would anybody else like to make a comment on things that they see missing or a weakness in the plan? I know for myself, if this helps the conversation, I'd like to see public announcements and press releases on certain big items. I didn't really see that in our communication plan. And then this concept of external intergovernmental communication, so the bar, for example, that needs to be in this communication plan, as well as with the associations. That was about external intergovernmental.
That's good.
Yeah, I think we need to do more with the bar association.
And I would say, if I may,
Please.
I see that Facebook and Twitter are listed, but I encourage them to look at other social media platforms as well, like Instagram. I don't know, I'm not Snapchat. I don't know, but those are not the all and end all.
Okay. I think it was stated earlier, and I'll just restate it, I think we really need to focus on our website though, before we do the social media. And it's important, I think, because a lot of people communicate that way. It'll be interesting to see how we can communicate to that platform effectively, but the website, if you just go to that, you'll see that it's pretty, it is very lacking, yeah. But there's a lot of great information, and I want to thank everybody who's participated in getting it there. And again, we have the lean staff, and I think, Ms. Bruning, you're part of handing the information over to someone, and they're putting it on the website, so.
Well, it's really goes to using our pro rata services, the internet team. So our office doesn't physically alter the website itself. We don't have anybody on site. We have a liaison.
Yeah,
really.
So, on the other hand, are you, no, keep talking, please.
I don't want to cut you off.
No,
I think we do need to focus on our website, but I think we do need to look into social media going forward, taking advantage of the best that it has to offer, because that's how the new generation is getting information.
So do I understand, Ms. Finner, that the social media, if it were done, would be done by OPS services?
They would be the one that are actually updating it, yes, that their staff are, the person that's assigned to
So
us.
we would give them
iOS.
content and then, okay.
For the social media would be OPA.
Yes.
But it's the information officer, you say. The information officer that's assigned to us would be the one that would actually be physically dealing with that.
But you would have to feed that person.
Yes.
We need to come up with.
So we go back again to, I mean, that's well, I mean,
It's content.
that the content is a huge part of the whole process.
At the same time, I think we do have a lot of really great content already that people don't know about. And just like I said, all the different things the task force have done this last year, all the best practices and how-tos. That website is packed with great stuff that we can just take piece by piece and blast out and let people know that it even exists.
So who would do that?
More to the point, how do we alert the community that there is such
I think we would rely upon our friends at CCRA and DRS to say, like the CRB board page. It has
in the schools?
in the schools. I don't think that would be difficult to find in the community,
I'm just saying we should.
but it does take some time, yes.
So we talked earlier about our staff and the things that they currently have before them.
Yes.
So how would we get this new product online and helping the staff do the social media? In other words, should there be another subcommittee to help them because they can't do it on their own? Who's going to do that?
What did you just say? Sorry for our staff.
Taking this task, but by the way,
On top of everything.
on top of everything else, I mean, the
I
social
mean, I can
media.
certainly help, and I think it'd be easy to call out things from our website, so I'm not creating a lot of content. But,
As just a comment, I sincerely appreciate that, but also the goal is to have information clear on the website to maybe we don't answer as many phone calls, for example.
Yeah.
So do a bit of work on this issue, and then it maybe helps you in another area. And then another thing that we could use social media for is to do things like send out our public notices, such as the meeting notice. Maybe people aren't looking at their emails so much anymore because they're relying on social media for those types of announcements. So it'd be just one more place to have it, but I don't know, we don't know yet if it's going to be useful.
I think it
We haven't tested it.
We do it.
I do too.
Paula, how are you understanding the needs of the website? So do you sit down with people and put them in front of the website and see how they maneuver through it?
No, and I think if you're basing on, you're asking based on what I just said, is just getting phone calls from people asking for information and us directing them back to the website where it's at. So if they called us based on the phone number that they got on our website, they were already there.
Right. But they never had the information because it's cleverly hidden.
Right.
It's kind of tricky.
Well, and based on what you said too, maybe that what our webpage, we need to do with our webpage is look at how it's organized. Because maybe the information is there, but maybe it's not recognizable that it's there. And so maybe there, a little review and analysis needs to be done.
As a person who's just on it this week looking for things, I don't know if it's OCR and that there could be a search feature like find a word and then go to that page. If it were OCR, it might help. I don't know if it is or not.
So it sounds like the consensus is definitely the website needs to be looked at first and foremost and assessed and analyzed for a more clear representation of all the information that folks should get. So with that, obviously the staff can't do it all by themselves. So would someone like to have a subcommittee to help them with the licensees in particular? Yes.
I'm looking at something
right. And then, you know, it doesn't have to be anything formal, it could be conference calls, meetings, just helping the staff work through.
I mean, Rosalie, I would say Rosalie, I can work on it, and this, you know, and I don't know if we need to have anything as formalized as that. Do we just email back and forth? Because really we're talking about content versus graphics, or and how maybe sometimes I think it boils down to wording as far as what's recognizable to somebody. How easy is it for them to find it?
Yeah, I think that's I agree. And I'd be happy to help serve on that.
Yeah.
Would that help the staff? Yes. Okay. So, talking then about timeline, do we want to give ourselves some boundaries or, by the start of the year, do we want to say we'll get the website done? Done? Sorry. This is a bad, aggressive timeline, I understand. But I always think if we create a group, give ourselves some markers, it doesn't have to be done, but what are you thinking?
Well, I think what first needs to be done is a review of the website, and then suggestions about maybe, and this is probably what the group needs to do, is analyze the website. What are the things that really need to be highlighted? Our experience really comes from when we go to a website when we're looking for something. I always, for me, a good website is how easy is it for me to find what I'm looking for.
Yes,
that's why I think the easiest thing, the first thing to do is see if it is OCR, if it could just a search feature for a keyword.
I agree.
Right, because I don't think that's there right now. And that might be the easiest thing to do.
Yeah, I agree with you.
So possibly the suggestions or feedback from the board members by a deadline, but then we'll have to integrate our, we have to actually coordinate with DCA OIS. So that'll be a different time in January.
Yeah.
Any comments down here?
And would it be helpful to you, Paula, or, because I know the focus group and subcommittee of two, oftentimes we may not see everything, and I don't know if it's helpful to maybe ask ERA and CCRA to send out a message to their membership to say, hey, can you go on the website, if there's anything that you see that is an opportunity or needed, email Paula. I mean, I'm not saying, contact have someone, they have to be
Alias.
At least it's not a phone call, right?
There you go, it's not a phone call.
So I think whatever my boss tells me. We can have, or a generic, info at, send it to a generic mailbox.
Can I modify your suggestions?
Absolutely.
Well, I think it's a good idea, but if I could modify it for the associations that they ask us of their members and have somebody within each of your associations have it funneled to that person, they can comprise a list and then send it on to,
If you could, then
Yvonne, and we'll send it
if
to
they're
Rosalie and
volunteers.
myself, and we, something along that line.
That's a
Yeah,
great
because I don't know the
suggestion.
end of
I just know they're
100.
like
Yvonne.
Yeah,
right.
No, it's true that they use the website more than ever, and so they will see things that
And
are
it's clear, it's really for them, it's a super great website.
It is, there's a lot of great
It's kind of an
information on it.
experienced place a little bit.
I would love to have pictures of
Yeah.
people on there.
But in the meantime, and I think this is something we could start working on right now, is that search feature. That is really a very commonplace on any website.
I'm not sure, I'll check that out.
Okay.
So-
I see that's a
It
possibility.
does have a search feature,
So, it does, yeah.
but it's very big.
Yeah, and I think that a
It's
lot of the
complicated.
pages aren't searchable.
Yeah.
Just a couple of pages are searchable.
There's something weird when you switch.
Would you like to come forward?
There's something weird that happened with the searches, at least for disciplinary actions, when everybody switched over to Breeze. So when you talk to your tech folk, I don't know if that affected things in this, because it is difficult to search,
Yeah.
which means there's something wrong. I'll give them the search algorithm as if I know what I'm talking about. But there is something strange that happened when you shift over to Breeze, at least with being able to search. for
We're
this.
not on Breeze, just to be
Oh,
clear.
you're not? Okay.
Not yet.
I will go sit down. Bye.
But there might be something else as it's your work, funky going on, so. All right, so, can you still?
Can I just add one thing?
Absolutely.
I know that the subcommittee is Rosalie and Tony, but I would encourage Carrie as the new board member maybe looking at it with fresh eyes. So there are other consumers that are looking at that board meeting. There are people that are looking to complain and they're not licensees. So the licensees are going for a particular type of information from our website. But the consumers, as far as the litigants, the attorneys, might be looking for a different type of information. So if you guys have input, please get that to me, to Rosalie, to Tony.
Okay.
Mr. Rosati has a statement. Shall I?
Absolutely, please come forward.
Tricia Rosati, a freelancer in San Diego. I do routinely go on the CRB website, and I've noticed that under licensee information, that there's never email addresses listed. And I don't know if that's a privacy issue.
It is.
Okay,
Yeah.
because sometimes
Yes, I would.
we're not allowed to collect them. Okay. And then also with the Facebook page, I do know that if you do create a public Facebook page where people can like it, it automatically comes up in, as a suggestion in other people's feeds, news feeds. So attorneys and other professional organizations would automatically see your page, and so that would also generate interest in the page.
Thank you very much. So, making a motion to create the subcommittee, and is that necessary, or? Yep, sounds like it. So would a board member like to make a motion for staff and the subcommittee work together to implement the communications plan?
And just to clarify,
Absolutely.
of course, this is a two-member subcommittee.
Yes.
By law.
I just want to clarify.
Yeah.
Thank you.
Okay, so,
Yeah, we do.
and we need to specify who those two people are.
I know, I didn't think that was correct. That's why I was questioning, because I don't think you have to have a motion to create a subcommittee. You can create one as
Just
chair.
for consistency's sake, because earlier we did that, so just be consistent.
Okay, thank you, Rose. So I had in mind Rosalie and Tony for that. Is that something you all are okay with them?
I know you're not allowed to make motions, so, are you?
I actually can make a motion.
Yes.
What would you?
Can you please make a motion?
So I'd like to make a motion to create a subcommittee of Tony and Rosalie to work with staff with the communications plan implementation on websites and other media platforms. Is that broad enough?
That's perfect.
Okay. Is there, thank you. Public comment? Further discussion?
Yeah, what was resolved about the date, or was there a time?
I think I was told we'll do as best as we can.
All right, I just wanted to make sure I wanted to make sure that was.
Yeah, I mean, wouldn't it be nice if we could say 2017, we're launching a new website or we're launching a new social media. So I'll put that little bug in the ears of staff and
Okay, so
and
was
the
there a
subcommittee. There was a second, and now we got our discussion, and now it's time for roll call.
Ms. Crum?
Yes.
Ms. Kosinski?
Yes.
Ms. Winchella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurd?
Yes,
Motion carries.
thank you. Looking at the time, can we just take a 2-minute break to allow one of our board members to exit? 2-minute break to allow one of our
2 minute break for someone to leave.
And then we'll know later on how many committees you're on.
Right.
Yes.
You're a great woman to leave.
Really?
We're back in session. Ms. Crum is off to do the yeoman's work in the courtroom. So we are almost done with our meeting. We are now at the point of future meeting dates, which is agenda item 10. Let me get it real quick. I know we have a lot of things that we're wrestling with right now. So we're talking about unlicensed practice of court reporting, our strategic communications plan, there's an exam development workshop that's still out there. That's right. Ms. Finner, there are a couple other items too that we discussed that will need to be at our next meeting.
Yes.
Yes, so do folks have a feeling about meeting before 2017? What are thoughts?
Oh, our task force has yet to meet, so.
Do you think it's going to be realistic that we're going to meet in November?
No.
I
don't know, we have to pull, I don't know, the availability is.
Yeah, I don't think, you think it's going to be another meeting of us this year?
Well,
Looking at early than next year?
I see that as a separate issue because that's on its own track. I think that we have possible legislative deadlines that we may be up against, and so we would need the subcommittee that's going to be working on the firm issues, the 270 issues, so to speak. They need to meet, they need to have time to meet and get some kind of consensus before we bring it back to the board. So that's the only caveat. Yeah, that's what we would need time to do that.
So.
I would suggest December, but that's typically pretty difficult to get people together, so I'm not sure if you'd want to make it fairly early in January. I think that November is unrealistic, because it's already being in September.
Okay. So maybe you can poll folks for December or early year.
Either's fine.
The sooner the better, because as I said, there's a lot of stuff on our list to do, and we do need time in the interim to work on them behind the scenes before we come back.
But don't the subcommittees need to get together?
Yeah, that's right, I mean, behind the scenes, we need to do subcommittee work, and
So we're looking again at generally Fridays, right?
I don't think we've been that specific, but she'll send out a poll and we'll figure out what days definitely work or not work for folks. Does that sound like a plan? Okay. And I guess we'll be meeting in Sacramento since we're down here this time around. Any public comments on this agenda item? Suggestions, something? Okay, great. All right, so now we're on to agenda item 11, public comment for items not on the agenda. Does the public do? Yes, please come forward.
So again, my name is Jennifer Escobar, and I'm a freelance court reporter here in San Diego County. And I did want to broach the subject that's been drawn to my attention, or my attention has been drawn to, from fellow court reporters that I am either colleagues with or have worked with. And that is the subject of once a transcript is submitted to an agency, apparently some agencies are taking it upon themselves to make changes to the transcript without the express authorization of the reporter or the reporter doing it themselves. I happened to do a search on the CRB's website earlier today to look for any guidance that the CRB may have posted regarding that subject. I did find a document dated in November of 2007 as a result of my search, but unfortunately, due to the time limitations when the meeting started, I wasn't able to read through the document thoroughly and see if there's been an opinion that's been expressed by the board regarding that issue. My hope, though, is that by bringing it to your attention, especially with the commentary about beginning more communication on social media, that there will be some guideline or guidance available to freelance court reporters in the future regarding that topic. I, for one, have been asked in the past by an agency to make a punctuation change in one of my transcripts. It was a matter of style that they use on their cover pages, and I was open to that suggestion. However, my fear is that it's a slippery slope with any changes that are made, especially since we turn the transcripts over to the agency and then more than likely never see them again unless we're on the same case in the future and happen to catch a copy of it as an exhibit. So that's one thing that I wanted to comment.
Thank you for your testimony. Since it's an item that's public comment, we can't really address your comment in detail.
We can't address it at all.
In detail at all, we're not going to say anything.
Understood.
We'll use semantics. The point is that we can't respond. Other than thanking you for bringing that to our attention.
Sure.
Of course, contact the board with any specific complaints that you have, letting us know what you've seen.
I can follow up with you.
Okay, thank you, Ms. Hunt. Thank you very much.
Any other public comments?
Brooke Ryan with CCRA, just want to thank you all for your time. I know how much work we all do, and we all need to just let you know how grateful we are. So thank you.
Thank you for your comments. That would be comment on. Thank you. Okay, so we've now reached item 13, which is a closed session. I don't believe we're going to have one. Oh, we are.
Yeah.
We are?
Oh, that's okay. It will be very short, but yes.
Okay, it will be very short. So we will now.
Do you have something? I'm sorry.
I would just like to publicly thank the Assembly Speaker's Office for letting us use their room once again. And their staff has been amazing. Brian Temporal especially has been very accommodating and very helpful. So I publicly wanted to thank them on behalf of the board and staff for the use of this great room.
Thank you, so it's very important, I appreciate you. I would like to thank you for all your arranging of this meeting.
You're welcome.
You did a lot.
And for clarification, it's the speaker emeritus.
Thank you. Don't want to correct me on that.
Great speaker Rendon upset. No. It will be. Thank you.
Thank you. So we will now go into closed session.
Goodbye.